Hey, folks, my name is Joel Zink. I'm going to be the presiding judge over your match today. Um, I'm not sure if everyone's here yet. It's not quite 6. We've got a little bit of time, but I'm going to leave it up to you guys to make sure that you let me know if we're missing people when we start from your teams, okay? Okay, thanks. Hi, everybody. As I was saying just a few moments ago, my name is Joel Zink. I'm going to be the presiding judge over this trial today. I believe I should have teams Blanca and Shavano. Is that correct?
Yes, Your Honor. Blanc is here.
Okay, and can I have a representative from Shavano just confirm that you're here?
Yes, Your Honor, we're here.
Okay, fantastic. Is there anybody missing from either team right now?
I believe we have everyone we need.
Okay.
Blanc as well, Your Honor.
Okay, so for the time being, I know it's about 6 o'clock, but I'm waiting for some jurors at the moment. So we're going to go ahead and just give them a little bit of extra time to get here, and then we'll get things started and rolling. Thank you, everyone.
Sorry, I should have said something. I'm a juror, Daniel Hersey.
Mr. Hersey, how are you?
I'm all right.
That's good to see you. So for the purposes of this tournament, I'm just going to ask you to, if you don't mind, leave your camera off so that we can preserve a little bit of bandwidth for these folks here.
Sure.
Thank you. Ms. Fuller, would you mind muting your microphone?
Yes, Your
Thank
Honor.
you. Thank you. We'll go over all of that in a few minutes here. I just admitted someone named John Uri. Are you a member of a team or a juror?
I'm a juror.
Okay, Mr. Uri, pleasure to meet you. My name is Joel Zink. I'm going to be the presiding judge today.
Nice to meet you.
Absolutely, likewise. So I will just be waiting for one more juror and then we'll get things rolling, okay? I don't need a confirmation. That's what we're going to do. Thanks.
Copy that, sir.
Your Honor. Before we get started,
Yes,
would
sir.
it be possible for the parties and yourself to go into a breakout room for a brief moment?
Why would we be going into a breakout room?
There is just a potential conflict that I just want to let known by the court before anything gets started, and just for the sake of transparency.
So just per the rules of this tournament, I'm the only party here that could declare a conflict, myself or one of the jurors. If there's something that you want to make me aware of, feel free to do that right here. But I'm not going to put us into a breakout room. And obviously, I appreciate, it sounds like you're trying to be candid about some kind of possible issue. So if that's something you want to discuss, go ahead.
Yes, Your Honor. Mr. Uri was a judge on the round that we participated in yesterday evening, where we were the same party in the case. So I'm not sure if that presents a conflict, but I did want to make the court aware of that.
Okay, it may be. So let me look into that a little bit. Just give me one moment and I'll look into that. Thank you, Mr. Pyron. I appreciate that. Mr. Uri, I think that you may need to be somewhere else. Let me look into that real quick.
Okay, just let me know where you want me.
Sure thing. Okay. Yes. So, Mr. Yuri, you need to be in court 7 with presiding Judge Deanna Sada.
Your Honor, that's the courtroom I just came from.
Okay, and
I was told to come into this courtroom.
so there's been an okay, just give me a second, Mr. Yuri. I'll contact Mr. Keys. It's possible that Ms. Sada didn't have the updated juror sheet. So just give me one moment, okay?
Okay.
And folks, this is just bound to happen. And as I'm sure that you've seen these kinds of things come up. So I appreciate everyone's patience. And there we have Ms. Thompson. She will be the other juror. So just give me one moment, please. And Mr. Yuri, just to be clear, was there some kind of conflict in courtroom 7 as well?
That's what I was told. I don't know the nature of it. I was just told there was a conflict that I needed to come to courtroom 10.
Okay, just give me a few moments, and I've contacted Mr. Keys, fellow sort of running all this, and you'll have to just give me one moment,
Okay, standing by.
of course. Folks, I may disconnect briefly, but I will be right back, and it may be that I have to readmit you all, but just hang tight, okay? Can everyone hear and see me? Thank you.
Yes, sir.
Yes, Your Honor.
Ms. Thompson?
Yes.
Hi, how are you today?
Good. How are you?
I'm doing pretty well. You're a juror on this case, correct?
Yes.
Okay, fantastic. Thank you for your time this evening. I'm not sure if you were here for all of it, but we're trying to figure out where Mr. Yuri is supposed to be. So I appreciate you just hanging tight before we get rolling here.
Cool. Thank you.
Thank you. Hello, Ms. Hersey.
I'm here.
Hi, are you a juror?
I am.
Okay, give me one moment, okay? Were you told to come here just now?
I was because of a
Okay.
conflict.
All right, nope, that sounds about right. So just give me 1 minute, and I keep saying 1 minute. Just give me some time.
Take your time. I'll mute again.
And Ms. Hersey, since you'll be here judging this round, I'm just going to ask you to leave your camera off to preserve bandwidth, okay? Thank you. Okay, Mr. Uri, I have the official word from Mr. Keys. You're going to be going to courtroom 8, please.
Courtroom 8? Okay, thank you, Your Honor.
I appreciate you.
Nice meeting you.
Absolutely. I appreciate you bopping around a bunch, but it's 2020. It's
It's
great.
2020. That's exactly right. Thank you, Your Honor.
Of course. Take care. Okay, folks, how's everyone doing tonight? My name, as I've said already several times, is Joel Zink. I'm going to be the presiding judge this evening. We have with us a few jurors. I believe it's Ms. Hersey, Mr. Hersey, and that would also be Ms. Thompson. Ms. Thompson, you can go ahead and shut off your camera as well. All jurors will do that so that we can preserve bandwidth. Quite a few folks in all of the different rounds going on right now using that bandwidth. So we want to preserve it for the folks who are participating in this trial. So next, I'm going to ask you all to enter your appearances, and we will start with the plaintiffs, please.
Yes, Your Honor. On behalf of Cam Donaldson, my name is Justin Pyron, and I'm here with my co-counsel, Elizabeth Nielsen.
Great. Thank you very much. I'm sorry, you said you're with who?
Elizabeth Nielsen, Your Honor.
Elizabeth Nielsen. Okay.
Hello, Your Honor.
Would you introduce yourself as well, please? Ms. Nielsen, would you introduce yourself as well, please?
Hi, I'm Elizabeth Nielsen.
Thank you. And for the defense?
Good evening, Your Honor. My name is Rebecca Fuller, and I, along with my co-counsel, Peter Calderola, represent the defendant in today's case, Ms. Karen Beja.
Good evening, Your Honor.
Thank you. Good evening, everyone. I'm just going to be writing some notes real quick. I want to make sure that I have all of your names down, and I'm sure our jurors do as well. And I'm going to kind of make sure that I'm able to identify you. I know that we have your names in the bottom, so that'll help throughout the process. But for scoring purposes afterward, I want to make sure that I record this carefully. For the plaintiffs, was your team Blanca?
Yes, Your Honor. Blanca Peak.
Thank you. All right. So let me just ask the scoring jurors just to triple check here. Do we have any conflicts of which you're aware?
I do not think so, Your Honor.
Okay. How about Ms. Hersey?
No, not that I know of. Thank you.
Thank you. Of course. And Ms. Thompson?
No.
All right, great. And I'm not aware of any conflicts either, so we can proceed and get things rolling a little bit. Is the plaintiff ready to proceed?
Yes, Your Honor.
All right, and the defense ready?
Yes, Your Honor.
Fantastic. We are live streaming. I'm going to have everyone stand up and raise your right arm, please. Or stay within your camera if that's what you need to do. Please indicate by saying "I do" if you swear to abide by the rules of this proceeding and to conduct yourself in a manner that is honorable to this forum.
I do.
I do.
I do.
Thank you. Now calling case number 082263, Cam Donaldson versus Karen Beja. Am I pronouncing Ms. Beja's last name correctly?
Yes, Your Honor. I apologize. Yes.
Don't apologize. So that is actually the next thing that I'm gonna talk about. So this is obviously a strange year and a new sort of forum for a lot of us. With it being a Zoom trial, we're gonna have some hiccups here and there. I expect that everyone will be courteous and will be flexible with those kinds of hiccups. I will be doing my best, certainly, to do the same. There are some Zoom etiquette rules that I probably don't need to state at this point, but I'm going to anyway, just so that everyone's on the same page. First of all, I want everyone to do their best to stay muted unless you are speaking. And there are no exceptions to that, other than just the simple to make mistake of forgetting to turn it off. But I don't want anyone interrupting anybody or anything like that at any point. And that would just be normal etiquette in a courtroom anyway. Second, during open and close, I'm going to ask everyone except for the party who is presenting that particular part of the trial to turn off your video. I will be turning off my video during opening and closing, and I want everyone else to do the same. And that will be sort of our Zoom equivalent of letting that person have the floor. Obviously, if you need to object at some point, turn your camera on. I don't necessarily expect that will be happening in an opening or closing, absent some pretty extreme circumstances. So does everyone agree that those are good ground rules for Zoom etiquette?
Yes, Your Honor.
Thank you. All right. So let's begin with housekeeping matters other than just those basic Zoom rules. Does the plaintiff have any housekeeping matters that it wishes to bring to my attention?
We do, Your Honor. First, can we assume that all witnesses have been constructively sworn in today's case?
Yes.
And can we further assume that all objection battles will be constructively heard outside the presence of the jury?
No, and let me clarify that. So just like in a normal courtroom, the beginning of any objection starts in front of everybody who's in the courtroom. If you feel that it's entering sort of a lengthier conversation or something like that, then you can ask to constructively approach the bench. But I expect that that's something you'll ask, and I don't want to need to sort of prompt that asking. Does that make sense, sir?
Yes, it does, Your Honor.
Okay. And anything else from the plaintiff?
Yes, Your Honor. Finally, does this court allow the manipulation of exhibits by zooming in or using the tools to emphasize certain aspects of it in order during examinations through as walking through as you would a demonstrative?
Yes, I think that that's fine. With it being this unique circumstances, I welcome anyone to take advantage of the tools that we have here in a Zoom court. Obviously, if somebody feels the need to object or feels that there's an issue with the particular way that something's being manipulated, I expect that they'll object contemporaneously.
Yes, Your Honor. With that, the plaintiff is ready to move to motions in limine.
Perfect. And before we do that, I want to move to the defense. Does the defense have any housekeeping matters that it would like to address?
Yes, Your Honor. Pursuant to Local Rule 44, I'd just like to let you know that my co-counsel and I will be communicating with each other exclusively through the Google Hangouts app on the iPad. Just to inform you of that fact, and that we are the only people on that channel. No one else will be communicating with us. Additionally, we plan to share exhibits using the share screen function, of course, only with permission, aside from during opening statements when we have a good faith basis to believe that an exhibit will come in, and during closing arguments whenever those whenever exhibits have been admitted, if that is appropriate, Your Honor.
Yes, and I appreciate you, Ms. Fuller, for bringing this up. As I've alluded to when Mr. Pyron was speaking, I welcome the use of the technology that we have available here. When it comes to sharing your screen or to sharing an exhibit, I expect that you would ask permission to do that. And then when I grant it, if I grant it, you can go ahead and do that. As you've already stated, Ms. Fuller, during opening or closing statement, I expect that you'll just do that as long as you have the good faith basis during opening statement. Does that answer your question, Ms. Fuller?
Yes, Your Honor. On that note, there is an exhibit that we wish to use during our opening statements. When we conferred with opposing counsel pre-trial, they expressed that they would likely object to that exhibit. So we wanted to bring that up at this time. Would you prefer that we refrain from using the exhibit, or can we argue its admissibility at this point, or at least its admissibility to the point of using in opening statements, as we have a good faith basis to believe it will come in?
Why don't we wait until we get into substantive motions in limine, and you can, well, heck, why don't we just address it right now, since that's where we're at. What is the exhibit, and what is your good faith basis for bringing it in?
Yes, Your Honor. The exhibit is Bates marked for identification with ending in 009. It is a photo of a tiger that lives at Wild Wildlife, the business that the defendant Karen Beja owns. Our good faith basis, we intend to use this photo to give context to the issues in today's trial. Relevance is a very low bar, and this photo is relevant to the issues in this case, particularly Karen Beja's relationship with her husband, Lou Donaldson, the business that is conducted at Wild Wildlife, the business the defendant owns, as well as Ms. Beja's activities there as the owner of that business.
Okay, and for the plaintiff, what is the objection to this if they believe they have a good faith basis to use it during opening statement?
Your Honor, during our conference before our pretrial here now, we just expressed that we believe that this particular piece of evidence was irrelevant and it did not make a fact of consequence more or less likely in this trial. But if a defendant is willing to limit their use to only contextualizing the occupation of Wild Wildlife, the tiger sanctuary on which the defendant had lived with her late husband, then we would be fine with them having that good faith basis and using it in their opening.
Ms. Fuller?
Yes, Your Honor. As I said, we merely use this to give context in this case.
Okay, then I'm going to go ahead and allow it during your opening statement, or during the defense's opening statement. Anything else, Ms. Fuller? For housekeeping.
Yes, Your Honor. Because of our own space constraints, the advocate addressing the court will be doing so always from the room you see me in here. So my co-counsel and I will be switching out for the different witnesses and for opening and closing opening statements and closing arguments. Additionally, we do have a technology advocate that will be running this room's technology. So the mute function, the video function, the share screen function. So to introduce him, his name is Eddie Villarreal. When you hear me, I may ask him to share the screen or to take down exhibits, and that's who I'm addressing.
Great, that's fine with me. Seems appropriate. And I don't have any issues with that. And to address something you brought up a little bit earlier, which I didn't actually respond to, I'm fine with you all using technology to communicate as you need to. As we all know, we are in the midst of a pandemic that presents unique issues. So that's fine. If I see you on your phones, I'm going to assume that you're following the rules and that you're using that to communicate with your trial partners. Thank you, everyone. Anything else in terms of housekeeping from either party?
Just one final thing for us, Your Honor. May we assume that the jury instruction has been read prior to closing arguments?
Yes, you may.
Thank you, Your Honor. That concludes housekeeping for the defense.
Thank you. For the plaintiff, do you have any substantive motions in limine that you would like to address? And before we get into this, I do want to stress that I prefer that we keep these motions in limine brief. Thank you.
Yes, Your Honor. The plaintiff moves in limine to enter into evidence a request for a temporary restraining order filed by Lou Donaldson in this case. May I be heard?
You may. Briefly, please.
Yes, Your Honor. Just as a brief background, this is a wrongful death case about the death of Lou Donaldson, the late husband of the defendant. And prior to his disappearance and subsequent death, he had filed a temporary request for a restraining order. It makes a fact of consequence more or less likely and should be admitted at this time under Rule 402.
From the defense?
Yes, Your Honor. We would object to this piece of evidence being admitted as it is inadmissible character evidence under Rule 404B. It's also inadmissible hearsay under Rule 802. And finally, it is inadmissible under Rule 403 as it would confuse the issues in today's case.
At this time, I'm not going to admit the exhibit or allow testimony about the exhibit. If you want to try again and you think you can establish the foundation for it, and to overcome what I see as a pretty serious propensity issue, then you can go ahead and try and do that during the substance of this trial. But at this time, I'm going to deny that motion, Mr. Pirate. Anything else?
Yes, Your Honor.
Yes, Your Honor.
All right. Ms. Nielsen, go ahead.
Thank you. Your Honor, the plaintiff moves in limine to bar from introduction into evidence any statements by opposing counsel in the presence of the jury or any witness testimony regarding Lou Donaldson's occasional practice of flying airplanes without logging a flight plan. May I be heard?
Please proceed.
The plaintiff learned in discovery that the defense may seek to suggest that Lou Donaldson flew his airplane without logging a flight plan on the weekend he disappeared. The plaintiff seeks to bar this evidence under Rule 404, which prohibits improper character evidence and propensity inferences. And if this evidence is introduced, it will cause the jury to make an improper character inference in the propensity way that just because Lou Donaldson had occasionally done this before, that is actually what he did on this occasion.
From the defense?
Your Honor, we do not intend to use this evidence for propensity purposes. Our use of this evidence would be limited to the purpose of showing that if Lou Donaldson were to fly to Costa Rica, there may not be a record, and it's more likely that he could have disappeared that way, as opposed to the defendant causing his death.
To me, this seems similar to the evidence that we were just talking about. I'm leaning toward not allowing it to be admitted right now. But if you can establish it during trial and overcome the propensity argument that Ms. Nielsen has brought up, we can deal with that at that time. But at this point, I'm going to support Ms. Nielsen's motion to preclude that testimony and evidence at this point.
Yes, Your Honor.
Thank you. Anything else from the plaintiff in terms of motions in limine?
No, Your Honor.
From the defense, any motions in limine?
Yes, Your Honor. Our first motion in limine actually involves the piece of evidence we discussed, the temporary restraining order. Would you like to hear arguments on that piece of evidence at this time, or do you want to reserve ruling for the trial?
I'm so sorry, Ms. Fuller. Would you mind restating that for me, please?
Of course, Your Honor. I was just saying that the first motion limine we have actually pertains to the piece of evidence we discussed previously, the temporary restraining order. Would you like to hear argument on that at this time, or would you like to reserve that for trial?
Let's go ahead and reserve any issues about the temporary restraining order for trial, because at this point, I'm not allowing it in. So any further argument about it is sort of moot, unless, of course, it comes up during trial, as I've already said. So we'll go ahead and reserve that, Ms. Fuller.
Yes, Your Honor. Our second motion limine is to, there is a video and accompanying transcript in the case record of a man by the name of Exotic Bob. This video in its entirety is inadmissible hearsay under Rule 802. It's also, well, as we understand that this witness is stipulated to being unavailable under Rule 804A, none of the exceptions that must also apply under Rule 804B apply to this piece of evidence. Additionally, under Rule 404, this in this video, Exotic Bob discusses criminal actions of the defendant, Karen Beja, and it would be inadmissible under Rule 404 as character evidence. None of the exceptions apply to that evidence either. Finally, under Rule 403, this piece of evidence is unfairly prejudicial, and the prejudicial effect outweighs any probative value. I'm sorry, did you say something to me, Your Honor?
No. I said, is there a response from the plaintiff?
Okay, yes, thank you, Your Honor. We did not hear that. We have no objection to this being a barred from evidence.
Okay, so I want to be really clear about this as we go into the trial. This evidence that we're talking about is a video of someone named Exotic Bob. Is that correct?
Yes, Your Honor.
Okay, and you're stipulating that it will not be coming into evidence and that no one will be using it, and we're never going to talk about this again.
Yes, Your Honor.
Is that correct, Ms. Fuller?
Just to clarify, Your Honor, this includes both the video and the transcript.
Is that correct, Ms. Nielsen? Is that your understanding of the stipulation?
Yes, Your Honor, that is correct.
All right. Thank you, everyone. That is fine. Stipulation. So not really something that I need to be party to. Thank you. Anything else, Ms. Fuller, or for the defense?
One final, I'm sorry, Your Honor.
Don't be sorry.
There is a one witness in this case who mentions a misdemeanor assault conviction of the defendant's when she was 17 years old. This is inadmissible under Rule 609.
Are there any other rules it's inadmissible under?
Yes, Your Honor, inadmissible character evidence.
Thank you, Ms. Fuller. Any response from the plaintiff?
Your Honor, the plaintiff has no intention into introducing Ms. Beja's misdemeanor into the record today.
Okay, sounds like another stipulation. There will be no admission of any misdemeanor conviction. I expect that no one will be eliciting testimony about it, and we won't be hearing about it again. Thank you, everyone. Anything else, Ms. Fuller?
No, Your Honor, that concludes our substantive motions. We stand ready to open.
Fantastic. And for my own note-keeping purposes, who will be giving opening statements for both parties?
I will be giving the opening, Your Honor.
I'll be opening for the defense, Your Honor.
All right. So for the record then, that'll be Mr. Cal and giving the opening for the defense, and Ms. Nielsen giving the opening for the plaintiff. Is that correct?
That is correct, Your Honor.
Yes, Your Honor.
Okay. And as I already mentioned, what we're going to do here is everyone's going to shut off their cameras while each party is giving their opening statement. Ms. Fuller, do you have something that you'd like to address?
No, Your Honor. I apologize.
No, that's okay. Feel free to sit down or to whatever you're most comfortable with.
I'm only saying because my co-counsel and I are about to switch so he can give the opening statement.
Okay. All right. Well, that is just fine. So beginning with the opening statement. Ms. Nielsen, please proceed.
May it please the court. Your Honor, opposing counsel, members of the jury. A woman's greed is at the root of the case before you today. It was her greed that led her to take action early one morning. Her greed that deprived a son of his livelihood and a father of his life. That woman is Karen Beja. That father was Lou Donaldson, a self-made man who worked tirelessly to earn enough money to fund his life's dream. Wild, wild life, a rescue and sanctuary for big cats such as lions, leopards, and tigers. Lou wanted this to be a family business. So he brought in his only son, Cam, to be his assistant, his right-hand man, and together, Lou and Cam ran wild, wild life for years. It even became a joke that Cam knew more about the family business than even Lou did. Enter Karen Beja, Lou's second wife, a woman 20 years younger than himself, who he met and married after Wild Wild Life was already a successful business. The evidence today will show extensive issues arose in Lou and Karen's marriage in the 12 years after they said "I do." And as tensions between them escalated, Cam couldn't help but begin to take notice. And then one day, Karen's greed came to the surface and everything changed. You'll get to hear from the defendant, Cam, today, and he'll tell you how on the morning of Sunday, August 19th, 2012, he was awoken early by the sound of the security alarm going off at the sanctuary office. And he'll tell you he immediately jumped in his car to drive off to work to find out why. And that what he saw when he arrived was beyond concerning. The padlock securing the chain on the front gate had been cut, and the back entrance gate to that same sanctuary office was ruined. But before Cam could go inside with the police, out came Karen, smiling, carrying a lockbox. Karen told Cam that she had won, but at just what, Cam wouldn't learn until later. Well, Cam had just said goodnight to his father the Friday before and might have been planning on going over to his dad's house that day for family Sunday dinner. He had no reason to suspect at that moment that his father was dead or even missing. No one but Karen Beja yet knew that no one would see Lou Donaldson alive again. You'll get to hear from the defendant, Karen Beja, today too. And she'll tell you a story of what she was doing there that early morning. Listen to that story carefully. And then she'll also tell you what happened after that tragic morning. How within the week, she took over operations of Wild Wild Life and fired Cam, Lou's assistant and right-hand man, the person who knew the most about running Wild Wild Life. Cam never had Sunday dinner with his father because Lou never came back home and he was never found. The only thing of his that was found was his van with his only pair of glasses that he needed to see and his keys on the front seat. A few weeks later, Karen produced a document she'll claim to be Lou's last will and testament, a will different from any Cam had seen or known about before. This will and testament gave Karen Beja everything, and left Cam, Lou's only son, his only child, with nothing. Karen Beja, a woman who satisfied her greed by getting rid of Lou and claiming his entire estate for herself. Cam Donaldson lost his father and was left with nothing. Nothing but questions. Questions about one woman's motives and his father's disappearance. Members of the jury, at the end of today's trial, it will be time for you to answer some of Cam's questions. No one can give Cam his father back, but you will have the power to restore to Cam a little of Lou's legacy, to give back a portion of what was taken from him out of greed. We will ask that you find Karen Beja liable for Cam's losses, for Lou's disappearance, and indeed his death. Thank you.
Thank you, Ms. Nielsen. Does the defense have an opening statement?
Yes, Your Honor.
Thank you. Please proceed.
I hate her. She took my father away from me then, and she took my father away from me on August 17th, 2012. I hope she is attacked and eaten by one of her tigers. Those were Cam Donaldson's thoughts. Those were Cam Donaldson's words. And it's the hatred in those thoughts and words and what explains why we're here today. Cam Donaldson, the plaintiff in today's case, has been blinded by his anger for his stepmother, Karen Beja. My name is Peter Calderola, and along with my co-counsel, Rebecca Fuller, we have the privilege of representing Karen Beja, a proud business owner right here in Pioneer Statesville. Ms. Beja, she's a mother of tigers. Now I'd like to take a second to introduce you to Ms. Beja. Ms. Beja, would you please turn on your camera for a second so that the members of the jury may meet you? This is Karen Beja. Thank you, Ms. Beja. Now, to understand how Ms. Beja became a mother of tigers, we have to go back to the very beginning. Almost 20 years ago, Karen was out and down on her luck when her knight in shining armor appeared. That man was Lou Donaldson. She'll learn, Lou, he was already married. He had a family. But Lou and Karen, they fell madly in love. And the family, that wasn't going to stop Lou. You'll hear in 2001, Lou marries Karen. And just shortly before marrying Karen and meeting her, he started a business, Wild Wild Life. Wild Wild Life was a rescue for big cats, tigers, lions, and the like. And you'll hear that Lou and Karen dedicated themselves to Wild Wild Life, to building up this company into a $5 million company. You'll hear that they started this company to protect tigers just like this one. This is Tara, Lou and Karen's favorite tiger. One of the many things they shared together in their marriage. But you'll learn that Lou and Karen's marriage, it wasn't perfect. It had its problems just like any other relationship does. You'll hear that Lou Donaldson had a mistress in Costa Rica. But Karen loved Lou. They were going to try to work through this. However, on August 17th, 2012, Karen's life changed forever. Lou disappeared. And you'll hear on August 17th and the early mornings of August 18th, 2012, Karen was looking after some tiger cubs who had just been rejected by their mother. She had to go to the store on the early morning of August 18th, 2012 to get some supplies that the Cubs desperately needed. She goes to the store, gets the supplies, is on her way home when her car breaks down. So what does she do? She calls her brother, Carl Bannister. Carl, he's a deputy sheriff right here in Pioneer Statesville. And you'll hear that he was close by. You'll hear from his former testimony that he picked Miss Beja up, took her to her home, to those tiger cubs who were desperately awaiting her return and the supplies she was bringing with them. You'll also hear, after Lou Donaldson's disappearance, the sheriff's department investigated this disappearance. They didn't find any body. They didn't find any sign of blood or struggle. In fact, the sheriff's department determined that no foul play was involved in Lou Donaldson's disappearance. That's not the only thing you'll learn. You'll also learn that Lou, while not only having a passion for tigers, had a passion for flying. The plaintiff will even have to admit to you that his father would buy and sell planes all the time, never properly registering them. The plaintiff will even have to admit to you that his father had a suspended pilot's license at the time of his disappearance. Karen, she waited and waited and waited for Lou to return. 5 years went by. Karen, she realized that she might have to move on and maintain taking care of the business that her and Lou built together. So she did the only thing she could. She declared Lou Donaldson legally dead so she could receive the insurance policy that Lou had taken out for her in 2005. You'll hear that Karen was the sole beneficiary on this policy. Now we anticipate that the plaintiff in today's case will call before you a witness, Taylor Pride. Keep in mind, members of the jury, Mr. Pride wasn't hired until 5 years after Mr. Donaldson's disappearance. Conveniently, this was right when Miss Beja filed for the life insurance proceeds. Now, Mr. Pride will also get on the stand and tell you that he sent one employee to the country of Costa Rica to search for Lou Donaldson, a single employee. You're also going to hear from our expert, Mr. Chris Renard. And Mr. Renard will tell you that working on behalf of Summit Life Insurance Company, he investigated Lou Donaldson's disappearance and whether or not Summit should pay Karen the $5 million. You'll hear that Mr. Renard, he spoke to the sheriff's department. He investigated all the surrounding circumstances of Mr. Donaldson's disappearance. And it was his determination that Karen should be paid. Mr. Renard will also tell you that he looked into a will here before you today, that he conducted a signature analysis, and you'll learn that in the course of conducting that analysis, Mr. Renard determined Lou Donaldson's signature on the last will and testament, it appeared to be genuine. As the defense in today's case, we bear no burden. That burden, it rests solely with the plaintiff. And the plaintiff must prove to you that it is by a preponderance of the evidence, which basically means it's more likely than not. And they have to prove to you that it is more likely than not that Lou Donaldson is dead. That it was the intentional or reckless conduct of Karen Beja that caused Lou's death. That Cam Donaldson suffered damages and that Karen Beja's conduct was the result of those damages that Cam suffered. If even one of those elements isn't proved to you today, ladies and gentlemen, their claim fails. Now, my co-counsel will get up before you at the close of today's trial, and Ms. Fuller will harmonize all the evidence you heard today and bring this case together piece by piece. And it'll be clear, members of the jury, once you've heard all the evidence, that there is only one reasonable answer. Miss Beja, she's not responsible for Lou Donaldson's disappearance. The plaintiff, Cam Donaldson has been blinded by his hatred for his stepmother, Karen Beja. I hate her. I hope she is attacked and eaten by one of her tigers. I want the deed and everything to Wild Wild Life. And I want the insurance proceeds. Those were Cam Donaldson's thoughts. Those were Cam Donaldson's words. Thank you.
Thank you, Mr. Calderola. Does the plaintiff wish to proceed with its case in chief?
Yes, Your Honor.
Okay, fantastic. Before we get to that, I just wanted to let anyone know if there's a reason that anyone needs a recess at any point or needs to step away from the camera, just go ahead, let me know, and we'll take a little break. I know that sometimes, you got to step away. With that in mind, Ms. Nielsen, who will be your first witness?
Your Honor, we would like to call Cam Donaldson to the stand.
All right, and Mr. Donaldson. Hello, Mr. Donaldson. I know that we said earlier on that everyone was constructively sworn in, but Mr. Donaldson, do you swear to tell the truth?
Yes, I do.
All right, great. Ms. Nielsen, please proceed.
Thank you, Your Honor. Good evening.
Good evening.
Please introduce yourself to the jury.
My name is Cam Donaldson.
And where are you from, Cam?
I'm from here in Pioneer, Statesville.
Why are you here in court today?
Unfortunately, my dad's been gone for quite some time, so I'm bringing a claim against the estate.
I'd like to talk to you about your father. Is that okay?
Yes, that's fine.
What was your dad's name?
Lou Donaldson.
And what kind of relationship did you share with your father?
We had a pretty close relationship when I was a kid. We would always hang around, throw the baseball. As I got older, I went to college, and then afterwards, we actually got to work together. So for the past few, before his disappearance, we actually got to work together for quite some time.
And when you were a child throwing around that baseball, what was your father doing for work?
Well, he didn't have the best education, so he actually sold cars, used cars, and then he used that money to start up his dream, which was the Big Cat Sanctuary. It's called Wild Wildlife.
Can you tell us a little more about Wild Wildlife?
Yes, it's a cat sanctuary. So he brings in tigers, lions, any big sort of cat, and nurtures them. Some of them have unfortunately been abused in the past, so he brings them in, or some are extinct, and then they care and nurture for them.
And how did you feel all this time about your father working so hard?
It was inspiring just to see his work. To care about something so much. And then so it was nice to be able to partake in his dream together.
And how were you involved with his dream, the sanctuary, Wild Wildlife?
We would joke around that, I was like a mini me. And so I would kind of do everything. I would, write checks if they needed to, order supplies, care for the animals. I kind of did anything and everything.
And how long did you have that job?
Over 20 years.
Did you have a particular job title?
No, you could call me like a freelancer. I was an assistant, so I kind of, was, if you want to call it, like second in command.
And when did you stop working that job?
Unfortunately, I was fired. Karen fired me a few days after my father disappeared.
And to your knowledge, before that point, had your father, Lou, been disappointed with your work performance in any way?
No one ever told me I was performing poorly. I was there for over 20 years, and everything seemed fine.
You mentioned Karen. Who is she?
She is Lou's wife. Technically, that makes her my stepmother.
And did you ever talk with your father about his marriage?
We did. He would kind of tell me some things, and about 2 weeks before he disappeared, he actually discussed about filing for divorce.
And did you ever witness any disagreements between your father and Karen firsthand?
I did. They had gotten into a fight in the office about like 2 or 3 weeks before he disappeared.
And when your father came out of that fight in the office, how did he appear?
Yeah, I heard some commotion going on in the office. I heard him and Karen's voice. I mean, I couldn't really hear specifics. And he came out of the room and he was shaking.
Had you ever seen your father shaking like that before?
No, I haven't seen him shake like that. And he had told me that if anything would ever happen to him, that they should look into Karen.
Objection, Your Honor. This is hearsay.
All right, Ms. Nielsen, your response?
Your Honor, this is an excited utterance which falls under the exception to hearsay 8032. The witness has already described how his father came out of this fight shaken and upset, visibly so, and he's saying this immediately after a fight with his wife.
Okay, what we're going to do is we're going to constructively move out of the presence of the jury for a bench conference. We're going to keep this brief, but Mr. Calderola, what is your response, if any, to Ms. Nielsen's response to you?
Yes, Your Honor. 8032 doesn't apply in this case, as there was no timetable provided by the witness as to when the father had this argument and removed himself from the argument and left outside and made this alleged statement. That time component is pertinent to whether or not it was an excited utterance.
Ms. Nielsen?
Your Honor, if I may proffer?
Yes, please.
If the witness was asked when this statement was made, it would have been basically immediately after he came out of the office.
Okay, and just to help my memory here, what exactly is the statement being elicited? Word for word, please.
The statement is that Lou Donaldson told his son Cam that if anything ever happened to him, to have the police look into Karen.
Okay, what I'm going to do, and if you can both just go ahead and mute while I'm making my ruling. I'm going to allow this, but for a limited purpose. So what I'll do is constructively, before the jury takes the case, I'll include in my instructions a limiting instruction about the purpose of this statement. I am going to allow it under the excited utterance statement exception to hearsay. I'm also going to allow it under the exception of a, let me think here. I think it can go under state of mind as well, the state of mind exception to hearsay. So I'm going to allow it under both of those purposes. And I'm just making sure to make a good record here for the appellate court, if need be. I will give a limiting instruction to the jury at the end of this case before they deliberate, informing them that they're the ones that are responsible for determining the cause of Lou Donaldson's death, and that this statement isn't to, it can play into their determination, but that's up to them to determine. Does that make sense to everybody?
Yes, Your Honor.
Mr. Calderola?
Yes, Your Honor.
Okay, thank you, everyone. Please proceed.
Cam, we'll talk more about the circumstances surrounding your father's disappearance in a moment. But first, I'd like to talk to you more about your father himself. Besides caring for big cats, did he have any hobbies?
Yes, he loved to fly planes, and so it was always something he loved and enjoyed. And when I was a kid, I got to do. At first, it's a little scary, but then you get settled in.
So you did go on flights with your father?
Yes, I did.
And what kind of planes were these that he was flying?
I'm not an expert. I mean, they're not like fighter jets. They're just smaller planes that can fit like a passenger or two.
And when your father went flying, did he bring anything with him?
So he always bought his prescription eyeglasses. I mean, he was as blind as a bat without them. He normally have that and his keys.
And would he ever go flying without his glasses?
I don't think so. There's no way he'd be able to take off without his glasses.
Where did he fly?
All over the place. I mean, sometimes it'd be to a different state. I mean, sometimes he would go out of the country. I mean, Canada, Mexico, Central America. He'd kind of go all over the place.
And did he tell you if he was going to go on a trip?
He would normally tell me. Yeah, he would inform me beforehand.
Was there ever a time you knew him to go on a trip that he didn't tell you?
No, he would normally inform me beforehand.
Objection, Your Honor. That question called for speculation.
Ms. Nielsen?
Your Honor, it's a rationally based perception of this witness is telling us the regular habit of his father and their normal interactions. And so it would be rational for him to say that he believed that his father always told him when he went somewhere.
Mr. Calderola, I will note your objection for the record. I think it's an understandable and good objection, but I'm going to overrule it this time. Thank you, everyone.
Cam, did your father tell you about any trips that he had planned the weekend he disappeared?
No, on that weekend, I remember it was that Friday. So like August 17th of 2012, he had told me that he would see me on Monday unless I stopped by for dinner on Sunday. So I didn't think he had a trip planned just because he invited me over for dinner.
And what time of day on that Friday was that?
It was the ending of the business day.
And was that the last interaction you had with your father?
Yes. Unfortunately, that was the last conversation that we had.
What else do you remember about the weekend your father disappeared?
To make matters stranger, the alarm actually went off at the sanctuary. So I was worried that maybe someone had broken in, and then so I only live a few minutes away. So I got in my car and I drove there.
And what day was this?
This was Sunday, so 2 days after my father disappeared. It was pretty early, I think like six in the morning.
So what were you most concerned about at that point, hearing the alarm?
If someone had broken in.
And when you arrived, what did you see?
So when I arrived, the police were not there yet. They arrived after me, and there was there's a padlock on the front gate, and that had been snipped off or broken, and then the back gate was also broken into as well.
Would you recognize a photo of the broken lock if I showed it to you here in court today?
I believe I would, yes.
All right, directing opposing counsel's attention to the photograph previously stamped Bates number 004. It's located on page 28 of the case packet, directing the witness to the same. Cam, can you give me a verbal confirmation when you see it?
I have it in front of me. I didn't know if it was going to appear on the screen. My apologies.
Oh, no, not yet. Cam, what do you see in this photograph?
This is a photo of the padlock that was broken when I arrived there that morning.
And is this photograph a fair and accurate representation of the lock as you found it that morning?
It looks to be yes.
Your Honor, plaintiff moves to admit into evidence plaintiff's exhibit number 1, a photo of the broken padlock.
Any objection, Mr. Calderola?
No objection, Your Honor.
Very well, so admitted. And you may share it on the screen if you so please, Ms. Nielsen.
Thank you, Your Honor. You see my screen, Cam?
Yes, I can.
Did you ever find out how the lock was broken like this?
When I first arrived, no, I was confused. I mean, I don't know what could have cut it. And then a few minutes later, Karen and some guy I've never seen before starts walking towards me, and he's got a pair of lock cutters.
And you mentioned the broken gate. Would you also recognize a photograph of that if I showed it to you in court today?
I would, yes.
All right, I will direct opposing counsel's attention to the photograph previously stamped Bates Exhibit 005, directing the witness to the same. Cam, can you give me a verbal confirmation when you have that in front of you?
I have it pulled up.
Thank you, Cam. What do you see in this picture?
So this is the back of the sanctuary. It's a metal gate. I don't know how someone could have done this. I mean, some of the bottom part of the fence is like completely bent in, but that's how I found it.
Your Honor, plaintiff moves to admit into evidence plaintiff's exhibit number 2, a photograph of the ruined back gate.
Any objection, Mr. Calderola?
No objection, Your Honor.
Thank you. So admitted. You may
May I
share on the
publish?
screen. Yes.
Thank you. Cam, would this have happened on its own?
No.
Ms.
The police
Nielsen, I'm so sorry. Just to clarify for my own record keeping and for the court's record, plaintiff's 1 was the broken lock and plaintiff's 2 is the broken gate. Is that correct?
Yes, sir, that is correct.
Thank you. Please proceed.
What happened next, Cam, after you saw the broken lock and you were in the sanctuary?
The police had arrived and they had questioned Karen.
And did Karen tell the police anything?
Yeah, it was odd. She told them that she was the owner, but my father was technically the owner, and that was odd to me. And then she said that if they had any questions, they could speak to her attorney.
And did Karen say anything to you?
She did. She was walking towards me, and she had a lockbox, and I didn't understand at the time, but she looked me dead in the eye, and she said she had one.
Objection, Your Honor. That's speculation.
Ms. Nielsen?
Your Honor, my witness did not speculate. He admitted he did not know.
Nothing further needed, Ms. Nielsen. I'm going to overrule the objection, Mr. Calderola. Is there any other basis you want to make an objection on?
No, Your Honor.
Okay, thank you. Please proceed, Ms. Nielsen.
Thank you, Your Honor. Did you know what she had meant by saying she had won at that point?
At that time, no, but later on, I figured out what she meant.
You mentioned a lockbox. Did you recognize that lockbox?
Yes, so we all share one office, and it's normally kept in the bottom left drawer. And so that normally has a few legal documents along with my father's will.
Your father's will. What did you know about your father's will?
So yeah, I in my father's will, he it was advised that he would, it was his wishes that I would get a quarter of his estate. My mother would get a quarter, Karen would, and then the last quarter would go to Wildlife.
And about how much was your father's estate worth?
So I believe all in all, it's 10 million. Wildlife is worth 5, and then there is a life insurance policy that is for another 5.
So under this 4 shares program, how much would Wildlife have received?
So they would only get, I don't think they would get the life insurance. So it's just a quarter of 5 million. So I think that's 1.25 million.
And did you, Cam, inherit your share?
No, I got nothing at all, not 1 cent.
Why is it that you didn't inherit?
Karen produces this will out of nowhere that says she gets everything. I wasn't included at all in it. I wasn't mentioned. Karen gets everything down to the last dollar. And that's what she meant when she said she won.
Can you tell me about this will that was carried out? How was it different besides the benefactor?
I had never seen the language in the other will. If I die or disappear, that stood out to me. That wasn't in the one that my father drafted, but in that will Karen brought, it was in there.
Was there anything else unusual about that will, the timing of it?
It was strange. I mean, this was just a few days before there was a restraining order that my father tried to get granted.
And Cam, how have you
Looks
coped?
like Mr. Calderola might be trying to object, but I can't hear you.
Can you hear me, Your Honor?
I can now. Are you raising an objection?
Yes, Your Honor. I was objecting to leading of the witness.
I'm going to overrule that. But before we move on, Mr. Calderola and Ms. Nielsen, it sounds like we may be heading into testimony about a restraining order, which we discussed in motions in limine. Does anyone want to raise a contemporaneous objection?
Yes, Your Honor.
If I may proffer, Your Honor.
Please, let's move outside the presence of the jury. And Ms. Nielsen, let's hear it.
We're done discussing any restraining order.
Okay. Mr. Calderola, do you have anything else that you'd like to bring up or any requests to the court about the testimony that was just given?
Yes, Your Honor. We would request a limiting instruction or to strike the testimony about the TRO as it had already been ruled on in motions in limine.
I am going to grant the request to strike the testimony about the temporary restraining order at this time. Thank you, Mr. Calderola. Please proceed, Ms. Nielsen.
Cam, how have you coped with your father's death?
It's been difficult. You know, at first, you kind of wonder if he's ever going to come back, and you're hopeful, and you kind of reach a point where you have to accept that that person's not coming back, and it was hard. And then Karen kicked me out of Wildlife, and that was my father's legacy and dream. So the fact that I couldn't be a part of it, it's been tough.
Thank you. Your Honor, no further questions for this witness at this time.
I'm sorry, Your Honor. I think you're muted.
I am indeed. Thank you, Ms. Nielsen. Mr. Calderola, do you wish to cross-examine Mr. Donaldson?
Yes, Your Honor. May I proceed?
You may. Thank you.
Mr. Donaldson, I'd like to talk a little bit about your lawsuit today. You brought this lawsuit against your stepmother, Karen.
Yes.
And you said that Karen only cared about your dad for money, money, money.
Yes.
But in bringing this lawsuit, you're seeking all of Wildlife?
I mean, I worked there for 20 years, yes, and it was my father's dream. I would like to carry it out.
So you want the company, correct?
To carry out my father's wishes.
Is that a yes, Mr. Donaldson? Could I get a verbal response, please?
Yes, I'm so sorry. I think I cut out. Yes, my apologies.
And that company, Wild Wild Life, is worth $5 million, right?
That's how much it is worth.
You also want the proceeds under the life insurance policy.
Part of it, yes.
Well, you said that you want the entirety of the insurance proceeds, correct?
I'm sorry, you were cutting in and out. I'm so sorry about that. Could you repeat that? My apologies.
Of course, I'll repeat the question. Mr. Donaldson, you want the entirety of the life insurance proceeds paid to Miss Beja, don't you?
Yes.
And that's worth $5 million?
Yes.
So you're asking this jury today for $10 million.
I'm sorry. I'm so sorry. You keep cutting out. I am so sorry about that.
Mr. Donaldson, you're asking this jury today for $10 million, correct?
Yes.
You're telling this jury you deserve this money, right? Mr. Donaldson?
Mr. Donaldson, are you able to hear the court?
I'm so sorry about that, Your Honor. It's cutting in and out. My apologies. I'm going to try to restart it to see if that works. My apologies.
That's okay. That's okay. These are some of the hangups that we can all expect. So we'll just hang tight while Mr. Donaldson restarts, and we'll proceed with the question that you had, Mr. Calderola.
Yes, Your Honor. Thank you.
I don't know about you all, but I could use a cup of coffee right about now. I don't know what time zone everyone is in, but I need some.
Red Bull.
That's good. That's good. Folks, while we're waiting on Mr. Donaldson, oh, there he is. Mr.
Okay.
Donaldson, can you hear me?
Yes, I can hear you now. My apologies.
Don't apologize. It happens. Let's just keep trucking on. Mr. Calderola, please proceed.
Thank you, Your Honor. Mr. Donaldson, I'll go back to my question. You're telling this jury you deserve $10 million, correct?
I just want what my father's wishes were in his will.
So is that a yes to my question, Mr. Donaldson?
If that's what I just wanted, what was my father's wishes, nothing more.
My question calls for a yes or no answer, Mr. Donaldson. You're telling this jury you believe you deserve that $10 million, correct?
No, not 10. What was in my father's will.
Okay, Mr. Donaldson. Let's talk about your aspirations at Wild Wild Life. On direct examination, you said you were the second in command, right?
I was one of those. I mean, I was an assistant. So, I mean, you could view it that way, yes.
So, but you did say on direct examination that you were second in command, correct?
You could view it like that, was what I said.
Is that a yes, Mr. Donaldson?
I said you could view it like that, just to break it down.
So that is a yes, correct?
Yes.
You remember giving a prior testimony, a deposition in this case?
I do.
You know that you had to be complete?
Yes.
You had to be accurate?
Yes.
And you had to be truthful?
That is correct.
Now, Mr. Donaldson, you have that deposition in front of you, don't you?
Yes.
Directing you to the last page. That is a signature of authenticity.
Yes, it is.
Now, nowhere in this deposition does it say that you were second in command, does it?
No, like I said previously on page 2, it says I was an assistant. You know, you could view that like a second in command.
But nowhere does it say that you were second in command, right?
No.
That's the first time the jury's hearing this today.
Like I said previously, I said I was an assistant. You could view it like it, but it does not say those exact words.
That's right. You were an assistant, Mr. Donaldson. You ordered supplies.
I also wrote checks.
Yeah, you wrote checks. You answered the phones, right?
I did a little bit of everything.
Scheduled meetings.
Yes.
And you were in that assistant position for 20 years.
Yes.
Never getting a promotion?
No, I mean, that's not really how we kind of ran things.
You were never given any ownership interest by your dad?
No.
Well, I want to talk about your relationship with your father. On direct examination, you said that you used to go on flights with your father and that you played baseball, right?
When I was a kid, yes.
Referring you back to that deposition testimony we were just talking about, do you have that in front of you?
I do.
And that is a signature of authenticity on the last page?
It is.
And you know when giving this testimony, you had to be truthful.
That is correct.
You had to be accurate.
That is correct.
And you had to be complete.
Yes.
And you were under oath when you gave this testimony, right?
I was.
Nowhere in this testimony does it say that you used to go on flights with your father.
No one asked me about that.
Nor does it say that you played any baseball with your dad, right?
No one asked me about that. That's correct.
So this is the first time you're saying this today, correct?
No one asked me about it in that deposition.
Mr. Donaldson, you say you were close with your dad, right?
Pretty close.
You knew the ins and outs of his life.
What do you mean?
You knew about your dad's life, right? You knew everything about him.
Not everything.
But you knew most of what your dad did, right?
I mean, I like to think I knew my father. I wouldn't say I knew everything about him, though.
You knew his passion was for tigers.
Yes.
You also knew that your dad liked to fly airplanes.
Yes.
He would buy and sell them all the time.
He would.
Never properly registering them.
No, not all of them.
Your father, he also had a suspended pilot's license, correct?
He did.
Your Honor, at this time, may we constructively approach?
Yes, you may.
Your Honor, I'm about to get into a question that will elicit some testimony of a mention of a fact that was discussed on motions in limine. It's concerning the fact that Mr. Donaldson would sometimes never file flight logs.
I'm a little confused by your phrasing, Mr. Calderola. So someone can't sometimes never do something. So was it sometimes or did he never?
Sometimes he wouldn't file flight logs. Apologies for the phrase.
That's okay. I just want to make sure that we're being clear for the record. Ms. Wilson, will you be responding?
Yes, Your Honor. This is precisely the propensity inference that we brought up in motions in limine. If they bring this up in testimony, it will cause the jury to make the improper propensity inference that just because he had done this occasionally in previous times, that's actually what he did this time.
Is there an exception or reason that this isn't propensity evidence under 404? Prohibited propensity evidence under 404, Mr. Calderola?
Yes, Your Honor. In today's case, the plaintiff must prove to you that Lou Donaldson is dead. And this is directly to rebut that evidence under B. Under 404BI, It's to offer evidence to rebut that Mr. Donaldson is dead and that it's a possibility that he's living out his life in Costa Rica with his mistress.
Ms. Nielsen, do you have anything else you want to throw my way?
Yes, Your Honor. None of the exceptions of 404 B actually apply here. They can say they're trying to bring it in for another purpose, but if you look at it, Lou Donaldson, his actions don't fall underneath these, and it's still going to cause the jury to make that improper propensity inference, which would unfairly prejudice the jury in that direction.
Okay. Can either one of you please inform me, Mr. Calderola, you mentioned 404BI. What is that exact wording?
About the evidence there. I can move on, Your Honor.
Okay. I mean, I'm more than happy to continue discussing this, but if there's nothing else anyone can tell me about this, I'm going to preclude any evidence about him not putting in flight logs in the past. At this point, I think that's unfair propensity evidence that the jury shouldn't be able to consider. Thank you.
Yes, Your Honor. Mr. Donaldson, you know that there's 2,200 miles between Statesville and Costa Rica, correct?
Yes.
You're positive your dad's nowhere in that 2,200 miles.
No, that's because Karen made sure of that.
Mr. Donaldson, I'd like to talk about what you didn't know about your father. You didn't know your father had a mistress in Costa Rica?
No.
You didn't know how many planes your dad owned?
No, I just know he had a couple.
You didn't know where your dad stored all of these planes, right?
No.
You don't know what planes your dad would specifically fly to Costa Rica?
No.
Well, let's talk about the police investigation surrounding your father's disappearance. The sheriff didn't find any sign of blood?
I don't believe so.
They didn't find any body?
No.
They didn't find any sign of struggle?
I don't believe so.
And you're angry that the police didn't find any evidence, aren't you?
I am.
You didn't hire an investigator in 2012 when your father disappeared, did you?
No.
You didn't hire an investigator in 2013?
No, the insurance company told me I had 5 years, so I waited until like near the ending of that.
You also didn't hire an investigator in 2014?
No.
It wasn't until 2017 that you hired Mr. Pride to search for your dad, right?
Yes.
And conveniently, that was right before Miss Beja was going to file for the life insurance proceeds, correct?
They told me, the insurance company told me I had within the 5 years to do it.
But this was right before Miss Beja was going to file for the insurance proceeds, correct?
I mean, I didn't know when she was going to file. I just know the insurance told me I had 5 years.
Mr. Donaldson, you're not still searching for your dad, are you?
No.
Instead, you're here in court today suing Miss Beja for $10 million, right?
I'm suing her, but I don't believe it's that amount.
Let's talk about your hatred of Karen. You don't like Karen, do you?
She murdered my father. Why would I like someone that murdered my father?
Your Honor, may I move to strike? That was to non-responsive.
I am going to strike the testimony about murder. Mr. Donaldson, I order you to not use the word murder. Use any other words that you want to describe what you need to, but you're not in a homicide trial in terms of like a criminal case. Murder has a really specific legal meaning, and I think that and this is all constructively outside the presence of the jury. But Mr. Donaldson, I think it could confuse the jury if we use the word murder, okay?
Yes, Your Honor.
Thank you.
Mr. Donaldson, on direct examination, you said that Karen said she won, right?
Yes.
Referring you back to that deposition testimony we referenced earlier, you have that in front of you, don't you?
Yes.
And you know, in that testimony, you had to be truthful,
Yes.
had to be accurate,
Yes.
you had to be complete.
That is correct.
Nowhere in that testimony does it say that Karen says she won, correct?
It's on page 25 of the case packet, letting me know that she had won.
But nowhere in this deposition does it say that Karen said she won, as you said on direct examination.
It says it letting me know that she had won. In quotations.
Objection.
Basis?
Improper impeachment.
Sustained. Please move on, Mr. Calderola.
Yes, Your Honor. Mr. Donaldson, you haven't liked Miss Beja since the day your dad met her.
I've never been fond of her.
Your dad actually married Karen in 2001.
And he was going to divorce her.
Well, he married Karen, though, in 2001, correct?
He did.
And he left your mom.
He did.
You're angry at Miss Beja for leaving your mom. You're angry at Miss Beja for replacing your mom, excuse me.
Yes.
You hope that Miss Beja is attacked and eaten by one of her tigers?
Because of all the things she's done, yes.
Is because you hate her, right?
I do.
No further questions, Your Honor.
Thank you, Mr. Calderola. Ms. Nielsen, do you have any redirect? If so, will you be keeping
Very
it
brief redirect.
Great. Thank you, Ms. Nielsen. Please proceed.
Cam, do you miss your father?
Every day I do.
Thank you. No further questions, Your Honor.
All right. May this witness be excused, Ms. Nielsen and Mr. Calderola.
Yes, Your Honor, we ask that this witness be excused.
Anything else, Mr. Calderola?
A brief moment to switch out with co-counsel.
Oh, sure. I just mean in terms of Mr. Donaldson.
No, this witness may be excused.
Thank you. Mr. Donaldson, we appreciate your time today. You may leave the courtroom now. Does the plaintiff have any other witnesses that would like to call?
Yes, Your Honor. The plaintiff intends to call Taylor Pride to the stand. I would give the defense an opportunity to get themselves situated as they change rooms.
Of course. I'm actually, as we switch things up here, I think that everyone has to switch a little bit. I'm just going to take just like a 2 or 3 minute break on my end while that all gets situated. Okay?
Yes, Your Honor. So 8:35 or whatever the 35th minute is on the hour.
Yeah, that'll do. Thank you.
Thank you.
Are all parties present?
Plaintiff is here, Your Honor.
Defense is here, Your Honor.
All right, thank you very much. Who will be directing Mr. Pride?
I will, Your Honor.
Okay, and for the defense?
Cross-examining Mr. Pride.
All right, perfect. All right, plaintiff, go ahead and proceed. Thank you.
Good evening, Mr. Pride. Would you please introduce yourself to the jury?
Good evening. My name is Taylor Pride. That's Pride.
And what do you do for a living?
Well, I work as a private investigator at my own firm, Pride Investigations Incorporated.
How are you involved in today's case?
I was hired by Cam Donaldson in my capacity as an investigator to look into the circumstances around his father's alleged disappearance and to analyze what has been called his last will and testament.
Now, Mr. Pride, I want to go into that investigation, but before we do, I want to talk a little bit about your background. What did you do before you became a private investigator?
So I started my career as a patrol officer with the Pioneer Police Department in 1998. From there, I was promoted to detective in 2000 and was a detective with the department for 16 years.
In those 16 years that you were a detective with the Sheriff's Department, what sort of cases were you investigating?
Oh, I investigated every type of case. Economic crimes such as fraud and forgeries to violent crimes such as murder.
And what did you do after you left the police department?
After I left is when I started my own private investigation firm.
So as a private investigator, do you hold any special certifications?
Yes, I've been certified by the American Board of Forensic Document Examiners since 2002 now. Yeah.
And is that a type of certification you have to regularly maintain?
I have to recertify every 4 years, and my certification is up to date.
And what does that type of certification allow you to do?
Well, it means I'm qualified to make determinations of forgery on documents by conducting a handwriting analysis and comparisons.
And how do you do those types of handwriting analyses?
Well, I take a holistic approach. I consider the factors of the handwriting itself as well as the circumstances surrounding when a document is purported to have been written.
Mr. Pride, have you ever testified in court before?
I have. Since 2002, I've testified 15 times in both criminal and civil cases for both defendants and plaintiffs.
At this time, Your Honor, the plaintiff moves to enter Mr. Pride as an expert witness in forensic document analysis as well as investigations.
Any objection?
Your Honor, if we may be heard outside the presence of the jury.
Sure.
We have no objection to this witness testifying on his handwriting analysis expertise. However, we would have an objection to this witness testifying as to what may have caused Lou Donaldson's disappearance, specifically that Karen Beja, his conclusion that Karen Beja was responsible in this case. If we could take this witness on a brief voir dire to demonstrate that he's not qualified to offer that opinion.
Yes, and what we're going to do is we'll do that entire voir dire outside the presence of the jury. No, we won't. No, we won't. We're going to do it in front of the jury. Go ahead, Ms. Well, you're not. I'm showing you as
Mr. Villarreal, could you change my name?
Thank you. I've been relying on those.
Yes, Your Honor.
Your name is Ms. Fuller, is that correct?
Yes, Your Honor.
There we go. There we go. Ms. Fuller, go ahead with your voir dire. Please keep it brief if you can. I'd really appreciate it.
Yes, Your Honor.
Thank you.
Pride, you mentioned before that you were a detective.
Yes.
And as a detective, you would implement specific methods for investigating things like disappearances.
Yes.
For example, you might use DNA evidence.
Yes.
You might use fingerprint analysis.
That is some of the tools available to law enforcement to conduct their investigation.
And you mentioned several specific methods you used to evaluate handwriting samples in today's case, correct?
Yes.
But you didn't mention anything about specific forensic methods you used to come to your second opinion that Karen Beja was responsible for Lou Donaldson's disappearance.
No.
Your Honor, at this time, we've shown through our voir dire that this witness is not qualified to give an opinion on Lou Donaldson's disappearances. He's not relied on specific methods under Rule 702.
Mr. Pyron, we're outside the presence of the jury right now.
Yes, Your Honor. While we do not expect this witness today to testify that Ms. Beja herself was responsible for the disappearance of Lou Donaldson, he has testified that part of his handwriting analysis is by considering all of the factors around the supposed document. So we do believe that this witness should be able to testify into the circumstances around Mr. Donaldson's disappearance itself. It's well within his expertise as a private investigator. It's exactly the types of things that a private investigator does on a regular basis. And with his 16 years prior as a detective in the Pioneer County Sheriff's Department, it makes him more than qualified to testify as an expert on the investigation that was around Mr. Donaldson's death and disappearance, as well as his own conclusions that he drew from that investigation as it informs his handwriting analysis.
Okay, let's, what I'm not hearing, Mr. Pyron, is that you plan on eliciting testimony from Mr. Pride about an opinion regarding the cause of death or anything of that sort. Am I wrong?
You're not wrong, Your Honor. What we expect this witness to testify to today is how the suspicious circumstances around that disappearance informed his opinion on his ultimate conclusion that the will that was produced by Ms. Beja was in fact forged. While that might implicate Ms. Beja, he's not going to explicitly give an opinion that Ms. Beja was the reason responsible for that disappearance. Rather, what her connection was not only in his life, but also in the aftermath of his disappearance, and the types of questions that raised when he was asked to analyze this will that Ms. Beja ultimately produced.
Ms. Fuller, it sounds like they're essentially stipulating to not go into what you're objecting to. Is that a fair characterization of your objection?
Yes, Your Honor. I would just, as I'm not sure exactly how this testimony will play out, I would likely object if there's implication that Ms. Beja was somehow responsible for her husband's disappearance.
Okay, that's fine. What we'll do is, if anything comes up you think's objectionable, Ms. Fuller, it's your record to protect, so feel free to raise an objection if you need to. Same goes to you, Mr. Pyron, but at this point, I am going to admit Mr. Pride as an expert in both criminal investigations and in, I believe it was forensic document analysis. Is that correct, Mr. Pyron?
Yes, Your Honor.
All right, we'll proceed from here. Thank you, Mr. Pyron. Go ahead.
Mr. Pride, did you come to any opinions in today's case?
Yes, I did.
And before we go directly into what those opinions were, I'm just going to ask you a few questions on how you reached those opinions. What types of materials did you review in coming to your opinions today?
So I had the opportunity to review Mr. Donaldson's alleged will, his driver's license signature, the documents relied on by Mr. Donaldson's life insurance company, as well as interviews with one of the declared witnesses on Mr. Donaldson's will.
And is it standard practice in your field to use those types of materials?
Yes, it is.
And were those materials sufficient for you to come to your opinions in today's case to a reasonable degree of certainty?
Yes, they were.
And did you come to your opinions using reliable principles and methods?
Yes, I did.
And did you reliably apply those principles and methods to the facts in today's case?
Yes.
Mr. Pride, do you believe that your opinions would help the jury understand the evidence better?
Oh, I do believe it would.
Now, Mr. Pride, what was your opinion about today's case?
It is my opinion that the will produced by Karen Baja was not signed by Lou Donaldson, and that the signature appearing on the will was forged.
Now, Mr. Pride, what were the reasons behind that opinion?
I think it was forged for 3 reasons. First, the circumstances around Mr. Donaldson's disappearance are incredibly suspicious. Second, the will itself and the matter and timing when it was signed is also very suspicious. And third, a handwriting analysis of the signatures shows that it's unlikely that Mr. Donaldson himself signed the will.
Now, Mr. Pride, I want to walk through each of those reasons one by one. And that first reason that you gave was about the circumstances surrounding Mr. Donaldson's disappearance. When was the last time anyone saw Mr. Donaldson?
Mr. Donaldson was last seen on August 17, 2012.
And when did you get involved into this case?
Well, Mr. Donaldson's son, Cam, hired me in July 2017, so just under 4 years after his father had disappeared.
Now, once you got involved in the case, was anyone else investigating Mr. Donaldson's disappearance?
Yes, the Pioneer County Sheriff's Office had been looking into Mr. Donaldson's disappearance since 2012, and it technically is still active. It's an active case in their office. To date, they have not recovered Mr. Donaldson's body or made any investigation toward what Ms. Basha how she might have been involved in his disappearance.
Did the Pioneer County Sheriff's Department find any traces at all of Lou Donaldson?
They were able to locate his van, which was on an airstrip.
Did Mr. Donaldson own any airplanes?
It's my understanding that Mr. Donaldson owned an airplane and flew frequently as a hobby.
Now, from your understanding of the plane that Mr. Donaldson owned, would that plane be able to fly all the way to Costa Rica from Statesville?
Well, maybe. The thing is, due to the size of that plane, it would have had to stop and refuel, not just once, but several times in order to make it a trip that far.
Are there any other indications that Mr. Donaldson's in Costa Rica right now?
No, none at all. I even sent an investigator down to look for him, and nothing.
Are there any indications that Mr. Donaldson's still alive?
There's no indication Mr. Donaldson is still alive. In fact, his bank accounts have not been touched once since his disappearance.
Objection, Your Honor.
Basis?
At this point, I would re-urge that this witness is not qualified. If we may be heard outside the presence of the jury, he's testifying as to what he believes happened to Lou Donaldson. This goes beyond his expertise in handwriting analysis.
Well, to clarify, he's also been tendered as an expert in criminal investigations, which I approved. Mr. Pyron, do you plan on going any further with his testimony, or does that conclude this line of questioning?
That concludes this line of questioning, Your Honor.
Okay, Ms. Fuller, I'm going to overrule your objection at this time, and we'll proceed forward. But I will caution you, Mr. Pyron, if that line of questioning goes any further, which you've said it won't, I think that it would enter the territory that Ms. Fuller's objection leans on, and I would sustain the objection if it did go into that.
Yes, Your Honor.
Thank you.
Mr. Pride, I want to turn now to that second reason that you told the jury on why you thought that Lou Donaldson's will was forged. You mentioned that that was the circumstances surrounding the signing of the will itself. Would you recognize a copy of that will if I were to show it to you?
Yes.
I'm now directing opposing counsel and the witness's attention to page number 55 in the case packet. This is Bates stamp 0014. Do you see that, Mr. Pride?
One moment, please.
For the court's information, is this the last will and testament?
Yes, Your Honor.
Thank you.
I apologize as well. I said in the case packet it was page 55. It's actually page 53.
Okay, I have that in front of me.
And what is that, Mr. Pride?
This is the alleged last will and testament of Lou Donaldson.
How do you recognize it?
Oh, it's part of the material that I looked at in preparing to testify tonight.
Does it look substantially similar as the last time you reviewed it?
Yes.
At this time, the plaintiff moves to enter in document 0014 as plaintiff's exhibit number 3.
Any objection, Ms. Fuller?
No objection, Your Honor.
Okay, so admitted. Thank you.
Permission to publish to the jury?
You may, and just for the court's information, was that plaintiff's number 3?
That was, Your Honor.
Thank you. You may publish.
Now, Mr. Pride, what day was this will supposedly signed by Lou Donaldson?
The date on the will is June 14, 2012.
Now, is there anything that stuck out to you about the day, June 14th, 2012?
Yes, that would have been 2 days after Mr. Donaldson had filed for a restraining order against Miss Basha.
So why was it so strange? Why did that stick out to you then?
Well, it's hard to believe that 2 days after filing a restraining order against Basha, he would alter his will to leave his entire fortune to her at the expense of his child Cam.
Now, in your investigations, do you often review wills?
Yes, I do. It comes up frequently.
And was there anything that stood out to you about the language used in this particular will?
Yes. Unlike any of the wills I've reviewed, this will specifically said, in the event of death or disappearance.
Finally, Mr. Pride, who was it that was supposed to have seen Mr. Donaldson sign this will?
The other witness listed on the will is Samantha Lane.
And did you ever get in touch with Samantha Lane about the will?
Yes, I did speak with her. She told me that she signed the will as a witness after being threatened by Karen Basha.
Objection, Your Honor. Hearsay.
First of all, I apologize for not being on mute for this whole time. I hope that I haven't been disruptive. Ms. Fuller, your objection was hearsay, is that correct?
Yes, Your Honor.
Okay, Mr. Pyron, what's your response? And we're outside the presence of the jury.
Yes, Your Honor. This goes to the declarant's state of mind, particularly in this case, Samantha Lane, as she was describing to Mr. Pride under the duress in which she signed this will without having seen Mr. Donaldson present there to sign it himself.
And Mr. Pyron, can you once again, just so that I'm very clear on the statement trying to be elicited here, what are the exact words?
The exact words were that Miss Lane told Mr. Pride that she did not see Lou Donaldson sign the will, and that the reason that she attested in her signing it was because she was threatened by Miss Basha.
Ms. Fuller, any further response?
Your Honor, just to be clear, this opposing counsel says that exception 3 under Rule 803 applies. Is that the argument?
I believe that was his proffered exception. Is that correct, Mr. Pyron?
It is, Your Honor.
So, Your Honor, under Rule 803.3, it applies to statements that are made about a currently existing mental state. Ms. Lane was speaking to Mr. Pride after the mental state of being supposedly under duress and signing this will.
Mr. Pyron?
Yes, Your Honor. Directing the court's attention to the last line of 803.3, that allows an exception when it becomes the terms of the declarant's will. Because the defense in this case is alleging that this June 14th will is in fact Lou Donaldson's, the statements made by Ms. Lane here are directly questioning the validity of that and whether or not she had seen him sign it on that date.
Your Honor, if I may respond.
Yes, but this will be it.
Yes, in this case, Ms. Lane would be the declarant, and the will at issue is Lou Donaldson's, not her own.
Ms. Fuller, I'll note your objection for the record. I think it's a good one, generally speaking, but I am going to allow this testimony under 8033. Thank you. Please proceed, Mr. Pyron.
Mr. Pride, what was it that Samantha Lane told you when you asked her about the will?
She told me that she signed the will as a witness after being threatened by Karen Basha.
Now, I want to turn to that last reason that you mentioned about your handwriting analysis in particular. How do you go about conducting this handwriting analysis?
It's a three-step process. First, you get known samples from the author, like a journal or a notebook that they've written in. Second, you analyze known samples to look for handwriting characteristics and shapes, curves, angles, and stroke direction. Third, you compare those characteristics to the writing in question.
So in this case, were you able to obtain any original versions of Lou Donaldson's signature?
Yes, I was able to have his signature on his driver's license, his signature on the restraining order paperwork, and a note he had written to his son, Cam.
Now, you had mentioned there Mr. Donaldson's request for a restraining order paperwork. Would you recognize a copy of that if I showed it to you?
Objection, Your Honor. Pursuant to the court's prior ruling, the temporary restraining order, from my understanding, was excluded.
Well, it sounds like this is for a different purpose, though. Am I wrong, Mr. Pyron?
Your Honor, we are using it at this time to go into the comparison of the signatures between Mr. Donaldson on that request for a restraining order versus the one on the will. However, we believed at the end of motions in limine that the ruling by the court was that with the proper foundation laid for this piece of evidence, that it would be able to come in under a 404B2 exception because the contents thereof go directly to the intent, plan, and motive of Ms. Beja at issue in today's case.
Okay, I want to be very clear about my ruling here. I am not allowing the TRO, the temporary restraining order, for any reason in terms of propensity. If you're seeking to enter it as a handwriting comparison, would you want to redact the rest of the document? Do you think that that would be appropriate?
Yes, Your Honor. We will constructively redact the document outside of, in particular, the date on the document, as this witness has already testified, how that influenced his opinion on in today's case without objection from opposing counsel, as well as the signature itself.
Ms. Fuller?
So just to clarify, everything but the date and signature will be constructively redacted?
Correct.
With the understanding of the identification of the document, Your Honor.
Your Honor.
I'm not going to let the jury know that this was a temporary restraining order. So any testimony about that that's already come through will be stricken. What I will allow is that this was an official court document that your witness took a look at as a comparison for the purposes of the signature. Is that clear, everyone?
Yes, Your Honor.
All right. And for the purposes of the record, the rest of the document is going to be constructively redacted other than the date and signature. Thank you, everyone.
Excuse me, Mr. Pride, if I were to show you a copy of that court document that you reviewed, would you recognize it?
Yes.
I'm directing opposing counsel and the witness's attention now to case packet page 55. That is Bates stamp document number 0016. Do you have that in front of you, Mr. Pride?
One moment, please. Yes, I do.
Now, without going into the contents of that document, does that look like the legal document that you reviewed in coming to your opinions today?
Yes, it does.
And does it look substantially similar to the last time that you reviewed it?
Yes.
At this time, the plaintiff moves to enter this court document as plaintiff's exhibit number 4.
Any objection, Ms. Fuller?
No objection, as long as it's constructively redacted, Your Honor.
Okay, and so it shall be. Mr. Pyron, do you wish to publish or anything like that?
Yes, Your Honor.
All right, go ahead.
Now, Mr. Pride, what was it that was distinctive about Mr. Donaldson's signature on this document that you reviewed?
The way that Mr. Donaldson would write his L's with a smaller top loop at the top of the letter than at the bottom. He also used an extra hook in the O in Lou. When writing the first U in his name, he used a small tail at the end of the letter. And then finally, that second O in Donaldson, that's what we call a lazy letter because it's not clearly written.
Now, after looking at Lou's original signature, what was it that stood out to you that was different when looking at the will?
Well, in Mr. Donaldson's known samples, he would rarely lift the pen when signing. On the will, it looks as though the signer had 2 distinct pen strokes. The lazy second O is used throughout this version of the signature, and there are quivering indications that the person signing was doing so very slowly.
So what did that lead you to believe about this signature on the will itself?
That the signature on the June 14th will was not Lou Donaldson's.
Are you aware of any other wills that Mr. Donaldson might have had?
Yes, there was his valid will.
And in that will, how much money would Karen had received from it?
$1.25 million.
And after she produced this will, this June 14th will, how much money did she receive from it?
$5 million.
Thank you very much, Mr. Pride, for your patience. No further questions at this time.
Ms. Fuller, you have a cross-examination?
Yes, Your Honor.
Please proceed.
Mr. Pride, I'd like to talk about why you're here today. You no longer investigate crimes for law enforcement purposes, correct?
No, I did that for 16 years and hung up the shoes.
Instead, you're paid by individuals to investigate.
Yeah, I have my own firm.
In this case, you're being paid by the plaintiff, Cam Donaldson.
Yes, that's correct.
You were hired to investigate the validity of his father's will.
Yes.
But the plaintiff didn't hire you until July of 2017.
Yes.
Lou Donaldson disappeared in 2012.
Yes.
And that's nearly 5 years after Lou Donaldson disappeared that you were hired.
Yes.
But it's only 1 month before Karen Beja filed for her husband's life insurance policy.
Yes.
You don't believe that Lou Donaldson is in Costa Rica?
No.
In part because you sent one employee to search for him there.
Yes, that's one of the things I did.
You sent one employee to search the entire country of Costa Rica.
Yes, I sent an employee to search and ask around in a country that's geographically actually not that large.
You're also aware that there are 2,200 miles between Statesville and Costa Rica.
I am.
Your one employee didn't search those 2,200 miles.
I'm not sure what you mean by that.
I'll move on. I'd like to talk about your opinion regarding Lou Donaldson's will. You believe the will is forged.
Yes.
You believe that Karen Beja is responsible for that forgery.
Yes, I do.
But you didn't compare any of Karen Beja's known handwriting to the signature on Lou Donaldson's will.
No.
You would agree you had the expertise required to compare signatures.
Yes, I'm an expert in handwriting analysis.
But you chose not to do that comparison.
To do what comparison?
To compare Karen Beja's handwriting to the allegedly forged signature.
Well, that wouldn't have been proper in this case.
You did not do the comparison, correct?
No, I didn't need to do that.
I'd like to talk about Lou Donaldson's financial records. In preparing your report, you pulled all of Lou Donaldson's financial records.
Yes.
And when you wrote your report, it was your belief that Lou Donaldson didn't spend a single cent after August 12th, 2012.
That's what the bank records indicate.
So that belief that nothing was spent after August 12th, that was a fact that you based your opinion on in this case.
Yes, I take a holistic approach, and that was one of the facts that I used to come to my conclusion today.
Referring the court, opposing counsel, and the witness to what has been marked with Bates number 0015 or Bates number ending in 0015 for identification. Mr. Pride, have you located this exhibit?
Is this page 54?
The case record doesn't have page numbers throughout.
Okay. Are you referring to the bank statement?
Yes, Mr. Pride.
Yes, I have that in front of me. Sorry.
You recognize this exhibit.
Yes.
You recognize it because you reviewed it, informing your opinion for today's case.
Yes, I did.
You recognize it to be Lou Donaldson's bank statement.
Yes.
It is in the same or substantially the same condition as it was when you saw it last.
Yes.
Your Honor, at this time we offer what has been marked with Bates number ending in 0014 into evidence as Defense Exhibit A.
No objection, Your Honor.
Okay, so entered. And if you wish to publish, you may do that as well, Ms. Fuller.
Thank you, Your Honor. Mr. Pride, can you see the bank statement on the screen?
Yes, I can.
This bank statement was part of the financial records you reviewed for today, correct?
Yes.
You would agree that this final line on the bank statement shows that Lou Donaldson spent over $900 on August 17th, 2012.
Yes.
In fact, there are 3 transactions after August 12th, 2012.
Yes.
Which is the date you believed to be the last day Lou Donaldson spent a single cent.
Yes.
So one of the facts you based your opinion on in this case was wrong.
No, I still stand by my conclusion.
You stand by the fact that Lou Donaldson didn't spend a single cent after August 12th, 2012.
Yes.
No further questions at this time, Your Honor.
Thank you. And just for the record, who was the party marking on the exhibit?
That was our tech advocate, Your Honor.
Okay, just in the future, and that's fine if that's what you want to do. In the future, let the court know if anyone's going to be marking on any exhibits or anything like that, because I want to make sure that it's the right person doing it and that we're preserving things properly, okay?
Yes, Your Honor, we will absolutely do that.
All right. Any redirect examination, Mr. Pyron?
Yes, Your Honor. Mr. Pride.
Go ahead.
Excuse me. Sorry, Your Honor. Mr. Pride, is it typical for a private investigator to be compensated for their work?
Yes, that's how I make a living.
And would that compensation ever compromise any part of your investigation?
No, not in the slightest. Motivates me to do better.
Thank you, Mr. Pride. No further questions for this witness, Your Honor.
Okay, may Mr. Pride be excused?
Yes, Your Honor.
All right, Mr. Pyron?
Your Honor, at this time, the plaintiff rests its case in chief.
Okay, so just to be clear, no further witnesses or testimony or evidence from the plaintiff?
Your Honor, in the event that the plaintiff needs to bring a 106 objection just to introduce evidence as a part of completion to respond to the defense's case, there could be some testimony read onto the record, but at this time, we don't have any expectation for any other witnesses or evidence to come in on behalf of the plaintiff.
Okay, we'll cross that bridge if we get to it. But at this time, with the plaintiff resting, does the defense have any motions that it would like to make?
Yes, Your Honor. We do have a mid-trial motion that my co-counsel will be arguing. If you could give us just a second to switch rooms.
Of course, go on ahead. Who will be responding to the mid-trial motion from plaintiff?
I will, Your Honor.
Okay, thank you.
May I proceed, Your Honor?
You may indeed. Go on ahead.
Your Honor, pursuant to Civil Rule of Federal Procedure Rule 50, the defense moves for a judgment as a matter of law, as no reasonable jury could find that the plaintiff has proven all elements of their case. The plaintiff had to prove that Lou Donaldson was dead, that it was the intentional reckless conduct by Karen Beja, that Cam Donaldson suffered damages, and finally that those damages were caused by Miss Beja. The plaintiff simply fails here as they can't even satisfy element 1, Your Honor. They provided no physical evidence of Mr. Donaldson's death. As testimony was elicited, there was no body found, there was no sign of blood or struggle, nor was there any foul play suspected by the Sheriff's Department.
Mr. Pyron?
Yes, Your Honor. When viewing the facts in the light most favorable to the non-moving party, which is the plaintiff in this instance, a single reasonable juror could find that the plaintiff has met its burden in today's case. This is not a beyond all reasonable doubt. The burden is preponderance of the evidence, and there is substantial evidence that it's more likely than not that Lou Donaldson is in fact dead. We heard from his own son that he had not heard from him at all in the last 8 years. We heard from his son that his father had concerns about his wife and the sort of violence that she might have been capable of. And then we also heard from an expert, Taylor Pride, who had told us that his bank accounts haven't been accessed, that he hasn't been located in the place that the defendant tried to elicit that his location had actually been. Therefore, a single reasonable juror could find that the plaintiff has met its burden, that we have met the first element that Lou Donaldson is in fact dead. And this motion should be denied.
Thank you, Mr. Pyron and Mr. Calderola. I'm going to deny the motion at this time, but I appreciate Mr. Calderola's record, Mr. Pyron's record. We'll proceed with the defense case in chief. If the defense wishes to present evidence after a recess, I'm going to give us, actually, can we get a time check? How's everyone doing on time?
Your Honor, if we could just have a minute to consolidate our time between the timekeepers.
Yeah, of course. Once we get that time check done, we're going to take a quick break here. How long do you guys think you need?
Your Honor, we could be ready and back in 5 minutes, but we'll defer to the court's recommendation on how long we should take.
Mr. Calderola?
Excuse me, I thought that question was directed towards the timekeepers. Yeah, we could be ready in 5 minutes as well.
Okay. Once we get the time check, I'll make a final call, but thank you for your input. All right. So what I'm going to do is we'll just use this break to let them figure it out. And then whenever they've got it all figured out.
We appreciate that, Your Honor.
Yeah. Yeah. No, I'm terrible at addition and subtraction. I'll avoid it at pretty much any cost. So what we'll do is we'll take a 5-minute. Let's have you guys come back. It's 8:16 my time right now. So let's go 8:25. We'll do roughly 10 minutes, just a little short of 10 minutes. So 8:25, we'll all get back online. We're coming to the court, and then we'll get our time check and see where we're at with time for everyone. Okay. All
Yes,
right, everyone.
Your Honor.
Howdy all. We got a time check here, Mr. Renard.
Yes, Your Honor. So the plaintiff has used about 38 minutes and 50 seconds of their time. So they have about a little more than 31 minutes left. And the defense has used 26:34. So they have just a little less than 43 and a half minutes left.
All right. Well, let's get things rolling. Does the defense wish to put on any evidence or bring any witnesses before the court?
Yes, Your Honor. The defense now calls Mr. Chris Renard to the stand.
All right. It sounds like I called our timekeeper by a witness's name, so I apologize, everyone. Mr. Renard, everyone has been constructively sworn, but if you wouldn't mind raising your right hand and swearing to tell the truth. Do you swear to tell the truth? You're muted.
I do.
Okay, good. All right, go ahead, Mr. Calderola.
Yes, Your Honor. Good afternoon, Mr. Renard. Would you please take a moment to introduce yourself to the members of the jury?
Yes, my name is Mr. Chris Renard, and I live here in Pioneer, Statesville.
What do you do for work here in Pioneer?
So I work as an insurance claim investigator, and I'm also a forensic document examiner.
Who do you work for?
I work for Summit Life Insurance Company.
How long have you been an insurance claim investigator and forensic document examiner?
So I have worked with claim investigations for about 20 years now, and I've worked as a forensic document examiner for 23 years.
I'd like to take both of those in turn. What do you do as an insurance claim investigator?
So I do a variety of things. My main responsibility is to review insurance claims for potential fraud. And then in that, I also I provide advice for the company whether or not they should pay out the beneficiary on a life insurance policy. And so in that, I do risk surveys to assess the loss. I collect various pieces of evidence and documentation, and I also conduct interviews, investigative interviews. But like I said, I just review insurance claims and verify those claims whether or not there's been any fraud.
What does a forensic document examiner do?
So a forensic document examiner, like myself, specializes in document examination, and I do handwriting and signature analysis and identification. And I also look at records and determine whether or not they've been altered.
Do you have any certifications in this field?
Yes, I do. I am certified by the American Board of Forensic Document Examiners and the Association of Certified Fraud Specialists.
How do you make sure that you stay current in your field?
So I actively participate. I'm required to by the boards to maintain currency by going to these annual training workshops, and then I also complete continuing education credits that are related to the field.
Now, before going to work for Summit Life Insurance Company, what was your educational background?
So I initially went to the Statesville Police Academy, or excuse me, I initially got my bachelor's of arts in criminology. I got that in 1996. And then subsequently, I went to the Statesville Police Academy and I graduated from there in 1997.
Tell us a little bit about your experience in the field.
So I worked for the Statesville Bureau of Investigation for a while in their crime lab as a forensic document examiner from 1997 to 2000. And then I left for work at that point to work at my current job with Summit Life Insurance Company. And I've been an investigator and document examiner for them since 2000.
How did you get involved in today's case?
So I was assigned this case by the CEO of Summit Life Insurance Company. And the claim had been filed by the widow of one of our policyholders, Mr. Donaldson, on a life insurance policy that he held with us. So she was named the beneficiary on that policy, and the CEO wanted me to investigate the claim and make sure there wasn't any fraud involved.
Did you form an opinion in today's case?
I did.
What did you rely on in forming that opinion?
Well, I relied on some information that I obtained from the police, and then I also examined the last will and testament of Mr. Lou Donaldson.
Did you apply reliable principles and methods of your field in reviewing these documents?
Yes, I did.
Do you believe that your testimony today will help the jurors understand a fact and issue?
I do.
Your Honor, defense now tenders Mr. Chris Renard as an expert in life insurance claim investigation and also as an expert in forensic document examination.
Any objection?
No objection, Your Honor.
Okay. Any voir dire?
No voir dire either.
Okay, great. He is so tendered. You may proceed, Mr. Calderola.
Yes, Your Honor. Mr. Renard, you mentioned some information you learned from the police. Who are you referring to?
That would be the Pioneer County Sheriff's Office here in Statesville.
What did you learn from the Pioneer County Sheriff Department?
So I learned that the investigation into Mr. Donaldson's death was still open. And then I also was able to obtain some other information.
You say that the investigation was still open. Why would the investigation being still open be important to your investigation?
Well, it showed me that there had not been a determination on Mr. Donaldson's death yet, given that it had been 5 years since his disappearance. Or, excuse me, not his death, his disappearance.
What, if anything else, did you learn from the Sheriff's Department?
So I learned 3 facts in addition to the case still being open. First, that Miss Beja was never listed or charged as a suspect. Second, that Miss Beja had an alibi on the night of Lou's disappearance. And third, that the sheriff didn't find blood or any sign of a struggle at the scene.
I'd like to take each of those 3 points in turn. Referring to that first point you mentioned, why is it important that Miss Beja was never listed or charged as a suspect?
Well, again, at this point, the investigation had been open for quite some time. It had been 5 years since Mr. Donaldson's disappearance. So that was an interesting fact I found.
Moving to that second fact you mentioned, how is it important to your investigation that Miss Beja had an alibi?
Well, a person can't be in 2 places at once. So the alibi supported her story that she was at a particular location at the time of Mr. Donaldson's disappearance.
Finally, referencing that last fact you mentioned, why was it important that the police didn't find any sign of struggle or blood and determine that there was no foul play?
Well, like I said, there was no blood or sign of struggle found at the scene. And from that, the police believe there was no foul play. So that just indicated further to me that foul play is it's something that we have to look into whenever it comes to the paying out of an insurance policy.
Now, Mr. Renard, I'd like to talk about some other things you reviewed in your investigation. What documents did you review after Mr. Donaldson's disappearance?
So I investigated a variety of documents. I examined. I examined the insurance policy claim, and I also looked into Mr. Donaldson's last will and testament.
In reviewing that insurance policy claim, what was so special about the date, August 18th, 2017?
So August 18, 2017, that was the date that the claim was filed by Ms. Beja for the life insurance proceeds.
Why is that date important?
So this date was exactly 5 years after Mr. Donaldson's disappearance. It also was the first day that she could file based on the terms of the policy and the fact that she had to wait for 5 years to ask the court to declare him dead.
Did Ms. Beja filing for that claim on that first day concern you?
Sometimes whenever something like that comes up in the investigation, it can raise a question, but it does happen occasionally, and ultimately, based on the other things that I found, it didn't affect my final opinion.
What other documents did you review after Mr. Donaldson's disappearance?
Well, like I said, I looked into Mr. Donaldson's will.
In looking at that will, what jumped out?
One particular piece of information on the will did jump out a little bit to me was the language. indicated that Ms. Beja was going to be the beneficiary of the estate and the policy upon Mr. Donaldson's death or disappearance.
What did this language concern you?
I mean, it raised an eyebrow for sure. I hadn't seen it before in my time, but again, based on all the other pieces of information that I analyzed, it didn't change my opinion ultimately.
Moving to your analysis of Lou Donaldson's signature on the will, how did you review this?
So I followed various steps that we're trying to go through. I obtained some known signatures from various documents that had been signed by Mr. Donaldson before his disappearance, and then I compared the samples to the will. What samples did you get of Mr. Donaldson's signature? So Mr. Donaldson obviously had a signature on file with us at Summit Life Insurance. He signed a contract whenever he purchased his policy back in 2005. And I also obtained the signature copy form from the Department of Motor Vehicles. So that would be the document Mr. Donaldson had to sign whenever he got a driver's license. Referring the court and opposing counsel and the witness to what's been Bates stamped ending in 007. Mr. Renard, do you have this document in front of you? Yes, I do. Do you recognize this document? Yes, I do. How do you recognize it? Well, I was the one who created this document. What is it? It is a signature comparison that I compiled from the pieces of, or the samples that I collected. Is it in the same or substantially same condition as when you created this document or the last time you reviewed it before court? Yes, it is. Your Honor, defense now offers what has been Bates marked as 007 into evidence as defense exhibit B.
Any objection?
No objection, Your Honor.
Very well. It is so entered. Thank you, Mr. Calderola.
Thank you, Your Honor. May I publish?
You may indeed.
Mr. Renard, how did this analysis help you come to your conclusion?
So I was able to look at these signatures and compare them to the signature in question on the last will and testament, and I was able to apply my experience and knowledge and determine that there were sufficient similarities, excuse me.
What are those similarities?
So there's various similarities here in the loops and stroke of the signatures, the stroke direction, curves, legibility, angles, embellishment, and the capitalization also of the signatures.
Was there anything else you noticed?
There were some differences, but various differences can be explained by multiple different factors.
Now, Mr. Donaldson, after reviewing everything in this case, what was your final conclusion regarding the insurance payout to Ms. Beja?
My final conclusion on the insurance payout was that we were unable to there wasn't sufficient evidence to contest the claim. I wasn't able to find any instances of fraud, and ultimately I informed the CEO that Ms. Beja was entitled to the insurance proceeds and that there wasn't grounds to contest the payment.
I'll stop sharing screen now. Hypothetically speaking, what would have happened, Mr. Renard, had you or Summit Life Insurance found any sign of fraud regarding the claim for this policy?
Well, like I said before, the CEO had me investigate it for fraud. So if we would have found fraud, Summit ultimately would have denied the claim and would have kept the $5 million rather than paying it out to Ms. Beja.
No further questions, Your Honor. Pass the witness.
Ms. Nielsen, any cross-examination you'd like to give?
Yes, Your Honor.
Go on ahead.
You have been employed by Summit Insurance Company for about 20 years?
Yes.
And you've testified in court for your employer 24 times?
I believe so, yes.
And you've reviewed hundreds of wills in the course of your employment?
Yeah, that sounds right.
So you know if a will looks to be standard?
Yes.
And you would recognize if a will is a little unusual?
Yes.
And you would agree with me that Mr. Donaldson's will was at least a little unusual.
Yeah, yeah.
Lou Donaldson's will contained the phrase, "if I should die or disappear."
Yes.
Is it standard to find the phrase, "if I should die or disappear," in a will?
Not the disappear part, no.
In fact, Lou Donaldson's will is the only one of hundreds you've reviewed to include the phrase, "if I should die or disappear."
Yes.
Lou Donaldson was declared legally dead on August 18th, 2017.
Yes, I believe so.
And you concluded your investigation and submitted a report to your employer on September 26th, 2017.
Yes.
40 calendar days, 29 business days?
Yes.
And Karen Beja filed her claim for Lou Donaldson's $5 million life insurance policy on the same day he was declared legally dead.
Yes.
And you would agree that it is sometimes a cause for concern if that happens.
Yes.
You believe Lou Donaldson is dead?
Well, the court has declared him dead, yes.
You examined Lou Donaldson's signature?
Yes.
And you can't confirm to a reasonable degree of scientific certainty that the signature on the will genuinely is Lou Donaldson's?
Well, it appears to be genuine.
But you would agree that it's possible it's a forgery?
I guess it's possible.
But just not likely that it is?
Yeah, not likely.
Let's discuss the witnesses to the will. There were 2 witnesses to this will.
Yes.
And it's usually disfavored to have a beneficiary act as a witness to a will.
Yes.
Karen Beja was one of the witnesses to the will.
Yes.
And Karen Beja is a beneficiary of this will.
Yes.
Karen Beja is the sole beneficiary to this will.
Yes.
The other witness was Ms. Samantha Lane.
Yes.
You received a letter supposedly from Ms. Samantha Lane?
Objection, Your Honor.
Grounds?
I believe this line of questioning will attempt to elicit some hearsay statements.
Okay, let's step out of the presence of the jury. Ms. Nielsen, can you give me an offer of proof on where we're heading?
Your Honor, we are not going to offer this for the truth of the matter asserted, but rather as the grounds that the expert has used in examining the whole entirety of Lou Donaldson's will and estate, and the extent to which he followed through with his investigation. Under Rules 703 and 705 on cross-examination, the opposing party is allowed to elicit the data that might otherwise be admissible, even if you didn't agree that we weren't using it for a hearsay purpose.
Okay, with that proffer, Mr. Calderola, I'm going to overrule your objection for now. And we'll start heading down this path. If you think you need to renew an objection or anything like that, you can go ahead. But for now, Ms. Nielsen, please proceed.
Thank you. You received a letter supposedly from Ms. Samantha Lane.
Yes.
And that letter claimed that Ms. Lane never saw Lou Donaldson sign the will.
Yes.
And that
I would renew my objection at this time, Your Honor, under under hearsay, under 802, and responding to counsel's 703 argument. Your Honor, that 703 only applies when an expert may, when an expert the proponent of the expert attempts to disclose the facts after the reverse balancing test has been satisfied. Here, the plaintiff is not the proponent of this expert's testimony. Further, Your Honor, we would argue that the information contained in this letter about, and may we be heard outside the presence of the jury?
Yeah, this is all outside of the presence of the jury. I should have said that, but let's just assume. Go ahead.
Yeah. Further, we believe that this is improper propensity evidence under 404B, in that Ms. Beja would act in any wrongful way or illegal way by means of coercion.
Your response, Ms. Nielsen?
First, to the propensity argument, we're not offering that Ms. Beja would coerce anyone else because she coerced Ms. Lane. Second, under 705, the expert may be required to disclose facts otherwise inadmissible on cross-examination. And finally, I would say also that this goes to testimony that's already been heard today. Again, with the non-hearsay purpose, we already heard from Taylor Pride that Taylor Pride did talk to Samantha Lane and disclosed this same information.
So, yeah, this is not 404B or 404 evidence or anything like that. I would say that this is res gesti. This is part and parcel of the whole big issue that we're looking at. So I'm not going to sustain the objection on those grounds. I'm also not going to sustain the objection on the other stated grounds by you, Mr. Calderola, but it's noted for the record. And we're going to go ahead and allow the testimony at this time. Thank you.
Your Honor.
Please proceed, Ms. Nielsen.
Mr. Renard, that letter claimed that Ms. Lane never saw Lou Donaldson sign the will.
Yeah, I claimed that.
And this letter claimed that Ms. Lane had been coerced by Karen Beja into signing the will.
Yes.
And you investigated that letter.
I looked into it.
And you began your investigation by calling Karen Beja and asking her about the letter.
Yes.
And Ms. Beja confirmed that both she and Ms. Lane had seen Lou Donaldson sign the will.
Yes.
And then, after confirming this with Karen Beja, the sole beneficiary to the will, you then tried to contact Ms. Lane.
Yeah, I called her.
But you were unable to contact her?
Yes.
It was as if she had disappeared?
Yes.
In the end of your 40-day investigation total, you did not recommend contesting payment to Karen Beja of the $5 million life insurance policy?
Yes, that's correct.
Contesting payment would have required your CEO and Summit Insurance Company to go into litigation.
Yes, probably.
And that litigation would have been costly to your employer.
Yes.
No further questions, Your Honor.
Your Honor, can you, I'm sorry, it appeared we were experiencing some technical difficulties.
That's okay. Mr. Calderola, are you speaking right now? You're frozen.
Yeah, yes, sir. Can you see me? We might be having some Wi-Fi issues.
That's okay. That's okay. These things happen. You're starting to pick up steam again, so your picture's kind of coming through as we're speaking here. Do you have a redirect?
Yes, Your Honor. Brief.
Okay, you can go ahead. You're coming through and I can hear the audio just fine. Picture's a little choppy, just to let you know, but it seems like it's kind of getting there.
Yes, Your Honor. Mr. Renard, was it illegal for Ms. Beja to be a beneficiary on the policy?
No, not under Statesville law.
No further questions, Your Honor. Thank you.
Okay, may this witness be excused? Ms. Nielsen?
Yes, Your Honor.
Mr. Calderola?
Yeah, yes, Your Honor.
Okay, does the defense have another witness they'd like to call?
We do. Brief moment to switch out with co-counsel.
That's just fine.
Thank you.
Defense calls Miss Karen Beja to the stand, Your Honor.
All right. Ms. Beja, hello. I know that everyone is constructively sworn in already, but if you wouldn't mind unmuting, raising your right hand. Do you swear to tell the truth?
Yeah.
Cool. Thank you. You may proceed, Ms. Fuller.
Thank you, Your Honor. Good evening, Ms. Beja. Would you please introduce yourself to members of the jury?
Hi, my name is Karen Beja, and I'm the owner of Wild Wildlife, which is a business I used to run with my husband, Lou Donaldson.
I'd like to come back and talk about your business more in a minute, but first I'd like to talk about your husband. How did you meet your husband?
It's actually kind of a crazy story. I was hitchhiking one night, and Lou happened to be the one to pick me up. We spent that night together and never looked back. Guess you could say he was kind of like my, knight in shining armor.
How would you describe your husband, Ms. Beja?
So Lou and I were both very big advocates for the rights of animals. We were very passionate about that. But, Lou also was a bit of a loner sometimes. He had interests that he didn't always share with me.
Objection, Your Honor. That's improper character evidence under 404.
Any response, Ms. Fuller?
Your Honor, Ms. Beja is not offering any character evidence of Mr. Donaldson. She's merely describing her husband, and if allowed to proceed, will merely explain some of his hobbies.
Mr. Pyron, I get what you're getting at, but I think that this is just laying some background information in her relationship and how she perceived her husband. So I'm going to overrule it at this time. Thank you.
Ms. Beja, how would you describe your husband?
So like I was saying, Lou and I were both very passionate about the rights of animals, and we were big advocates for that. But Lou also was a bit of a loner, and he had some hobbies that, he didn't always share with me.
What hobbies were those?
For example, he liked to fish, but he was also a pilot, and he really loved to fly planes, and he pretty much did that by himself.
Do you have any idea where he would fly his planes?
I know that he used to go to Costa Rica pretty often.
Do you have any idea why he would go to Costa Rica?
I found out that he had a mistress down there.
How did you respond to that?
Not something that any wife ever really wants to hear or have to deal with, but we spoke about it and we were working through our marriage.
Ms. Beja, was there ever any talk of divorce?
Yes, Lou did mention it once, but like I said, we were working on it, and no marriage is perfect.
You mentioned trips to Costa Rica. As far as you know, did Lou ever have anyone accompanying him on these trips?
As far as I know, he always went alone.
Now I'd like to talk more about your business now. What is Wild Wildlife?
Wild Wildlife is a big cat emporium. It basically advocates for the protection of big cats. Like I said, it was something that Lou and I used to do together.
Let's pause just for a moment. Your Honor, are you still with us?
I absolutely am. I had to adjust my light over here. It was right in my eyes. Sorry about that, everyone. I was paying close attention. I want to make sure you know that.
Oh, I just wanted to make sure we hadn't lost connection. So.
Oh, great point. Nope, I'm still here. Thanks, everyone.
Perfect. So. So you were telling us about your business. For those of us who aren't familiar, Ms. Beja, what is a big cat?
Sure. So a big cat is an animal like a lion, a leopard, a tiger, things like that.
Referring the court, opposing counsel, and the witness to what has been marked with Bates number ending in 009 for identification. Ms. Beja, have you located the exhibit?
Yes, I have.
Do you recognize this exhibit?
Yes, I do.
What is it?
This is Tara. She's one of our big cats at Wild Wildlife.
And is this a fair and accurate depiction of Tara?
Yes, it is.
Your Honor, at this time we offer what has been marked with Bates number ending in 009 for identification purposes. into evidence as Defense Exhibit C.
Any objection?
No, Your Honor. As our discussion in pretrial, as far as providing context for the jury, we're all right with this exhibit.
Okay, well, then it is so entered. Thank you, everyone.
Your Honor, may I publish the exhibit?
You may. Thank you for asking.
Ms. Beja, are you seeing the exhibit now?
Yes, I see it.
What are we looking at here?
So this is Tara. She was actually, Lou and I's favorite cat at Wild Wildlife. And the reason we open Wild Wildlife is to protect cats like her who desperately need that protection.
Ms. Beja, what does caring for big cats like Tara entail?
It's so much work. I don't think people realize. For example, the night that Lou disappeared, I was actually taking care of these really young tiger cubs.
I'll stop sharing the screen at this time. Ms. Beja, I'd like to walk through what happened that night. Could you tell us exactly what was going on with those tiger cubs?
Sure. So they were just born a few days before and the mother had rejected them. So what happens is when that occurs, I have to step in and provide milk and formula for those cubs to make sure they survive.
Did you have that milk and formula, the supplies you needed at home with you that night?
I didn't. I actually realized pretty late in the middle of the night that I was going to have to make a trip to the store.
How did your trip to the store go?
It went fine until my way back, and then my car broke down. And on top of that, I realized I didn't even have my cell phone to call anybody.
What did you do?
I had to stop someone in the middle of the road, so embarrassing, and ask if I could use their phone so that I could call my brother for a ride.
Why did you choose to call your brother?
My brother's actually a deputy sheriff, and I knew that, I knew that he was on duty, and I knew that he was in the area that night, so I figured he'd be the best person to call.
About what time did you call your brother?
That would be about 3 a.m. on August 18th.
Now, when did you realize that your husband was missing?
Later that day.
What did you do when you realized he was missing?
I reported him missing to the police.
What happened after you reported your husband missing?
I waited. I waited to see if Lou would come back. I waited to see if the police would find anything. But year after year, I heard nothing, and I realized that I was going to have to move on with my life.
How did you move on?
I requested for a court to have Lou declared legally dead.
After making that, well, first off, was that request granted?
Yes, it was granted.
What effect did that have?
After the request was granted, I was able to probate Lou's will and also make a claim with Summit Life Insurance Company.
Your Honor, at this time, we would like to recall what I believe is Plaintiff's Exhibit 3, the last will and testament.
Sure. And by recall, do you mean to republish and discuss, or?
That was my next question. Yes, Your Honor.
Okay. That's just fine. It's already been admitted, so use it freely.
Thank you, Your Honor. What are we looking at here, Ms. Beja?
This is my husband Lou's will.
And Your Honor, at this time, I'll have my tech advocate highlight the first signature on the will, if that's okay.
Sure. I suppose I would prefer if any annotations or writing was done in response to questions or answers rather given by the witness, if that makes sense.
Yes, Your Honor. I just intend to use the highlight to direct attention to the signature I'm asking about.
Oh, sure. That's fine. That's fine. Now, just to be clear, that won't be able to be preserved as like a demonstrative or anything like that. If it's just for the purposes of calling attention to certain portions during the question, though, that's fine.
Yes, Your Honor. It'll disappear immediately.
Okay, great.
Ms. Beja, whose signature are we seeing highlighted here?
That's my husband's signature, Lou Donaldson's.
How do you know this is your husband's signature?
I know that's his signature because I watched him sign this document.
Ms. Beja, what did you inherit under this will?
After I probated this will, I became the sole owner of Wild Wild Life.
Was Cam Donaldson mentioned in this will?
No, he was not.
Whose decision was it to leave him out of this will?
That would have been Lou's choice because, you know, he chose what he wrote on that will.
Ms. Beja, were you aware of your husband having any other will?
No, this was the only will he had.
And I'll stop sharing screen at this point. Ms. Beja, you mentioned before that you filed a claim for your husband's life insurance policy. Did you receive anything as a result?
Yes, I filed a claim with Summit Life Insurance Company, and after they did their, process, I received $5 million because I was the beneficiary of that life insurance policy.
I'd like to talk about what brings you into court today. How did you become involved in this case?
I'm here because the plaintiff, Cam Donaldson, sued me after his father disappeared, and that's the only reason I'm here.
How would you describe your relationship with Cam Donaldson?
Cam's never liked me, and I knew that, but he's never done something as ridiculous as claiming I've done what he thinks I did.
Why do you say it's ridiculous?
Why would I hurt my husband? I loved my husband. There's just, you don't even have to take my word for it.
What do you mean by that?
Well, when I filed that claim with Summit Life Insurance Company, they did a thorough investigation and they found that I did nothing wrong. The police even looked into the disappearance and never said I was involved.
Ms. Beja, you've said that you inherited your husband's life insurance policy proceeds. What do you plan to do with that money?
I'm going to put it back into Wild Wild Life and make sure that it can keep going. That's what, Lou and I were so passionate about, dedicated our lives to.
No further questions.
Back to that last question, Your Honor, on relevance grounds.
Your response, Ms. Fuller?
Your Honor, if we may be heard outside the presence of the jury.
Certainly.
In this case, the plaintiff alleges that Ms. Beja killed her husband. The fact that she's using his life insurance policy proceeds to keep the business that they ran together going disproves that fact.
Mr. Pyron, your objection is noted for the record, but I'm going to overrule it at this time. Thank you.
Yes, Your Honor.
Mr. Pyron, do you wish to cross-examine Ms. Beja?
Yes, Your Honor.
All right, go on ahead.
Good evening, Ms. Beja. I just want to start asking some questions about your relationship with your husband, Lou. You mentioned on direct when you met Lou, you were hitchhiking, correct?
Yes.
So he picked you up off the side of the road.
He picked me up when I was hitchhiking.
And at this point, he was just a stranger to you.
Yes.
And then the two of you, you said you spent the night together.
I'm so sorry. Could you repeat that?
Absolutely. You mentioned that after he picked you up, the two of you spent the night together, yes?
We spent that night together.
And that was in a motel?
I'm not sure where it was.
It's your testimony today that you're not sure where you went with Lou that night?
Objection to relevance, Your Honor.
Your response?
Yes, Your Honor. Relevance is a low bar, and this goes directly to the credibility of the witness as how she described her relationship with her husband, especially at the beginning of that relationship.
I'm going to overrule the objection. Thank you.
Ms. Beja, Is it your testimony today that you don't remember where you went with Lou that night that he picked you up?
I do not remember.
Ms. Beja, do you remember giving a deposition in today's case?
You?
Do you remember your attorney being there?
Yes.
You remember an attorney for Cam Donaldson being there?
Yes.
And at that deposition, you were asked to be truthful, weren't you?
Yes.
And you were.
Yes.
I'm directing the witness's attention as well as opposing counsel to, if you're looking at the case packet, it's on page 43. Ms. Beja, are you looking at that now?
I don't think that this has page numbers on it. So do you know which page of my deposition you're talking about?
It's right on the first page of your deposition if you want to go by that. And if you look, it's, are you looking at your deposition now? That is your deposition, correct?
Yes.
It's your signature on the last page?
It's a signature on the last page.
That is your signature, Ms. Beja?
I believe this is a signature of someone named Kylan Burgee. So that's not my name.
I see. I apologize, Ms. Beja. You attested that this is your deposition though, correct?
Correct.
And you know that you had up to 24 hours before this trial to make any changes to it?
Yes.
Well, if you will follow along with me on that front page, you look about halfway down the page after the first exhibit is entered. Question, follow along with me as I read. Question, how did you and Mr. Donaldson meet? Answer, fun story actually. Pause, I was hitchhiking when I was rescued by my Prince Charming. We spent the night together at the motel.
Mr. Pyron, if you wouldn't mind just pausing for a second, I think we have an objection from Ms. Fuller. Ms. Fuller, what is your objection if I am correct?
Yes, Your Honor. I'm unsure if this is an impeachment. My witness said that she didn't remember. I don't believe reading from her deposition is the appropriate way to refresh her memory.
Mr. Pyron?
Yes, Your Honor. If this witness did not just say that she didn't remember. At first she said no, and then she followed up by saying that she didn't remember.
Okay. I'm gonna agree with Ms. Fuller here. If somebody says they don't remember something, I think the proper procedure is to offer them the opportunity to be refreshed, to have their memory refreshed. Now, certainly, I think that there might be an argument that an impeachment could happen in this kind of situation. But why don't we go ahead and give her an opportunity to be refreshed based on this statement first? Does that make sense, Ms. Fuller?
Yes, Your Honor. Thank you.
Okay. Really, either procedure is going to have the same effect with the court from the court's perspective anyway. But please, Mr. Pyron, give her an opportunity to be refreshed.
Yes, Your Honor. Backing up, Ms. Beja, it's your testimony that you don't remember where you spent that first night with Mr. Donaldson?
I didn't remember, but now that I've looked at this deposition, it does say that we spent the night at the motel.
Ms. Beja, you fell in love right away, didn't you?
Yeah, we fell in love, Mr. Donaldson. No.
You thought that Mr. Donaldson was your soulmate?
Yes, he was.
And the two of you then got married?
Yes.
And then you began working on his tiger sanctuary?
We ran Wild Wild Life together.
And you thought everything at that point was perfect?
I don't know that I thought that. I was happy.
Ms. Beja, is your memory exhausted on this issue?
I'm sorry, I don't understand the question.
After you began working on Wild Wild Life with your husband, you thought that everything was perfect?
Sure.
Now they didn't stay perfect forever, did they?
Our marriage wasn't perfect, no.
You fought with your husband?
We had issues like every marriage.
Is that a yes to my question? You fought with your husband?
Sometimes.
Your husband had asked you to get a divorce?
He mentioned a divorce once, but he didn't do it.
And you thought that your husband was cheating on you?
I'm sorry, could you repeat that?
Yes, Ms. Beja, you thought that Mr. Lou Donaldson was cheating on you?
Lou Donald, he had a mistress in Costa Rica, yes.
Now, you weren't Mr. Donaldson's first wife, were you?
No,
Mr. Donaldson was married before he met you, wasn't he?
yes.
And it is with his first wife who he had his son, Cam.
Yes, Cam is his son from the wife before me.
And you didn't like Cam.
Cam didn't like me.
It's your testimony today that you did like Cam then? Or are you saying that you guys didn't like each other?
We didn't like each other.
And you didn't trust Cam?
No, I did not trust Cam.
That's why the night of Lou's disappearance, you went into the office?
That's correct.
Now, Ms. Beja, I want to talk more about that night. This was August 17th, correct? That the cat litter was born?
I'm not sure what day they were born, but they would have been a few days old on August 17th.
And it was on the early morning, you said about 3 a.m. that you had to go get supplies for these cats?
I would have gotten the supplies before 3 a.m. and it was about 3 a.m. that I would have called for the ride.
Now, you mentioned that you didn't bring your cell phone with you when you went to the store.
No, I forgot it at home.
And then when your car broke down, you had to ask someone else for theirs.
That's correct.
But you didn't use this phone to call someone else at the Big Cat Sanctuary.
It was 3 in the morning, so I'm not sure if anybody else was there.
You didn't use this phone to call your husband, Lou.
I also wasn't sure where he was. No, I didn't.
But you used it to call your brother.
Called my brother. I missed the first part of the question. I apologize.
You used someone else's cell phone to call your brother.
Correct. Yes.
Your brother, who is a member of the Pioneer Sheriff County's police department.
Yes, he's a sheriff's deputy.
And that is the same police department that would investigate your husband's disappearance.
That's correct, yes.
Now, Ms. Beja, since Mr. Donaldson's disappearance, you've become a rather wealthy woman.
I'm not sure what you mean by that.
Well, would you consider millionaire wealthy?
I have acquired some assets after my husband disappeared, yes.
Let's talk about those assets. One of those was the entirety of his estate, isn't that correct?
Yes, because of the will that he left behind.
And that means that none of that money went to Wild Wild Life.
So the estate is actually Wild Wild Life.
But it didn't go to the corporation that you said that you're a business owner of, correct?
The estate was the business that I became the sole owner of.
The total value of that estate was $5 million, Ms. Beja?
That's correct.
And you were the only named beneficiary of that $5 million?
I was the only named beneficiary of the will.
And you also had a $5 million life insurance policy.
It wasn't my policy. It was actually Lou's policy.
Well, that policy was ultimately paid out to you, wasn't it, Ms. Beja?
Yes, I was the beneficiary.
So in total, if we're adding those together, that equals $10 million, doesn't it?
Yes.
That you received upon the disappearance of your husband.
It would have been 5 years after the disappearance.
Thank you, Your Honor. No further questions at this time.
Thank you. Any redirect from Ms. Fuller?
Yes, Your Honor, just briefly.
Okay, go ahead.
Ms. Beja, Did you have anything to do with your husband's disappearance?
No, absolutely not. Like I said, it's been looked into and I'm not involved.
Thank you, Ms. Beja. No further questions. Your Honor, may this witness be excused?
Mr. Pyron?
Yes, Your Honor. One brief question, if I may, on recross.
No. Okay, thank you, Ms. Beja. You may be excused. All right. Any further witnesses from the defense?
At this time, we would like to read in just a portion of the deposition testimony of an unavailable witness, Mr. Carl Bannister.
All right, Mr. Pyron, or from your co-counsel, any objection to the reading in? Any issues there?
No, Your Honor, not to the reading in. We just ask the opportunity under Rule 106 to, if there's any necessary completeness after that statement is read, to fill in the gaps for the jury.
Sure thing. I think that would be appropriate. All right, go ahead, Ms. Fuller.
Your Honor, may I read the deposition in question and answer format with my co-counsel reading the answers and myself reading the questions?
I think for clarity's sake, that's probably the best procedure.
Your Honor, would you like me to explain to the members of the jury what a deposition and what an unavailable witness are, or would you like to do that yourself?
Let's say that I constructively did that already, and you can just proceed.
Yes, Your Honor. Thank you.
Thank you.
Mr. Calderola, I'd like to start on the first page of the deposition at line 1. Hello, Deputy Bannister. Would you please state your name and spell it for the record?
Deputy Carl Bannister, that's CarlBannister.
What do you do for a living?
I'm a deputy sheriff for Pioneer County, Statesville.
Ending the reading at line 4 on the first page of the deposition and moving to the fourth and final page of the deposition, starting at line 10. Were you involved in the investigation of the disappearance of Lou Donaldson?
I'm sorry, counsel, where was this?
I'm sorry, that was fast. On the fourth page, the final page of the deposition, it would be the third question on the page.
I'm with you now, Ms. Fuller, sorry.
Were you involved in the investigation of the disappearance of Lou Donaldson?
No, it would not have been appropriate. I mean, I know the detective and investigators who looked into it. I have been working with them for years and we were all pretty close, but I was not personally involved in the investigation.
Did you have a chance to view any evidence or look at the reports?
No, I take my job seriously. I knew nothing of Lou's disappearance and I wanted to keep it that way. I was walled off from the investigation and that was fine by me.
Your Honor, that completes the portions of the deposition that we would like read.
Mr. Pyron, do you have any additional portions of that deposition that you'd like read into the record?
No, Your Honor. We are satisfied with the characterization of that deposition.
All right, so be it. Any other witnesses or testimony or evidence that the defense would like to present?
No, Your Honor. At this time, the defense rests.
Okay. Is there any motion that the defense would like to make?
Yes, Your Honor, and my co-counsel will again be arguing that motion.
Okay, thank you. Will Ms. Nielsen be handling any response?
Yes, Your Honor.
All right, great, thank you. Mr. Calderola, go ahead.
Your Honor, may I receive a time check, please, before proceeding on this motion?
Certainly.
Thank you.
I can tell you I'm personally not worried about our time right now, but let's get that check.
I can continue then, Your Honor, if you prefer.
Yeah, just go ahead. Keep it brief. I expect that it will be brief anyway.
Yes, Your Honor. Your Honor, at this time, we would renew our Rule 50 motion for a judgment as a matter of law. No reasonable juror or jury could find that the plaintiff has proved the 4 elements required in this case today.
Any response, Ms. Nielsen?
Yes, Your Honor. In viewing the facts most favorable to the non-moving party, in this instance the plaintiff, a single reasonable juror could find by preponderance of the evidence that it's more likely than not that Lou Donaldson is dead, that Karen Beja's conduct makes her liable for Lou's death, and that the plaintiff, Cam Donaldson, suffered damages as a result of the defendant, Karen Beja's actions. And as to that first element, death, we presented evidence that Lou Donaldson is dead. No one saw him alive after the evening of Friday, August 17th. He had no plans to travel. He did have plans to see his son either that Sunday for dinner or Monday at work. And he did not access his bank accounts. He never contacted his son since. The evidence shows it's more likely than not that Lou Donaldson is dead, and that Karen Beja had motive and conduct on or around August 18th to cause this death, and she benefited from his entire estate. For all these reasons, and Cam's losses caused by this conduct by Karen Beja, a single reasonable juror could conclude that we've proven all four elements of our case, and this motion should be denied.
Okay, thank you very much, Mr. Calderola and Ms. Nielsen. I'm going to deny the motion at this time based on the evidence that the jury has received at this point. A reasonable juror could find in favor of the plaintiff here. It's not my job to act as an extra juror. And that's why we have a jury here. So with that in mind, are the parties ready to proceed to closing arguments, or do folks need a break? We can take a brief break if people want or need to. I'll leave that up to you though. Are the plaintiffs ready?
The plaintiffs are ready to proceed to closing arguments, Your Honor.
Okay, and defense?
Defense is ready to proceed pursuant to just switching out with co-counsel, Your Honor.
Of course. And Mr. Calderola, since we'll be shutting off the cameras anyway, you guys can just do that right now.
Yes, Your Honor. Thank you.
Of course. Mr. Pyron, will you be presenting the closing argument for the plaintiff?
I will, Your Honor.
All right. I'm going to shut off my camera, and when I do that, feel free to start at any time, okay?
Before we begin, Your Honor, may I reserve 2 minutes of rebuttal time?
Of course. Do you, let's see, I think you both have like 15 minutes total right now. So is there a warning point that you'd like? I can flag that for you if you want.
Yes, Your Honor. So reserving 2 of those 15 minutes, if you could just give me a warning at 2 minutes of my initial closing remarks, that would be perfect.
Okay, so I am just to let you know, just in full transparency, I'm going to set a stopwatch on my own phone, or a timer rather, for 14 minutes. I'm sorry, for 13 minutes. Again, I already told you guys I hate adding and subtracting. So 13 minutes, and when that timer is up, I will just simply turn on my video, wave a hand, and then I'm going to stop. It's up to you to stop there if you want.
Yes, Your Honor.
Okay. Go ahead.
May it please the court, opposing counsel, members of the jury. When you think about all of the evidence that you've heard today and the testimony from the people who knew Lou best, the entire reason that we're here is because of one thing: greed. Greed that has robbed a son of his father, of his birthright, of his peace of mind, and of his closure. All because one woman, years ago, was picked up while hitchhiking by Lou Donaldson. Now, that woman was the defendant. And she told you today that she fell in love right away. But whether or not that was with Lou or with his money, that's going to be for you to decide, members of the jury. But after all of that, what we do know is that there is a son without his father here today. The plaintiff, Cam Donaldson, who has been so hurt by this one woman's greed that we're asking you to help him get justice. I'd like to remind you, members of the jury, that this today was not a criminal trial. We did not have to prove to you that Karen did what she did beyond all reasonable doubt. This is a civil trial, and because we're the plaintiff, we do carry a burden. But that burden here is only by a preponderance of the evidence. That just simply means more likely than not. You can think of it like a glass of water, where at halfway full, just one drop more means that we've met our burden in this case. Meaning that after everything you've heard today, if you think that it's more likely than not that Karen had something to do with why Lou is dead, you have to find for Cam Donaldson. Now, you've seen the defendant in today's trial, and you know that with her willingness to lie on legal documents, to lie to the police, and to sit up on that stand and lie to you, members of the jury, that we may never know exactly what happened to Lou on that night of August 17th, 2012. But as you just heard from the judge, you're allowed to use your common sense in deciding this case, members of the jury. So all of those gaps that the defendant won't tell you about, you get to decide what that means. But let's talk about what we do know. We know that on August 17th, 2012, Cam spoke to his father for the very last time. He told you today that his father told him, "See you next week, son. If I don't see you on Sunday for our family dinner." Cam never saw his father again. Now, this is important. Out of the two witnesses that you heard today that actually knew Lou Donaldson, there was only one who couldn't tell you the last time she saw him. But let's think about what she did tell us. She told us that the night that Lou disappeared, she had to take care of some cubs. In fact, she had run out of supplies, is what she said, and that she had to go to the store to get formula for those cubs. Now, members of the jury, this was an exhibit that the defense showed you here today. This was a bank statement from Lou Donaldson. And in this bank statement, look at what the last thing he bought just that day before: animal supplies for $1,000. Now, you also heard that this sanctuary was Lou Donaldson's life work. And for some reason, the defense expects you to believe that it being his life work, he somehow forgot that one crucial thing that they needed after those cubs were born. But that's not all that doesn't make sense about defendant's story about where she was instead. She told you she went to the store, but she also told you she left her phone at home. So there's no way to verify where she was. She told you that her car broke down and she needed some help. She didn't call her husband, who lived right down the street. She didn't call anyone else at the Big Cat Sanctuary. She called her brother. And you heard that her brother worked for the very same police department that spent the last 8 years finding nothing on why Lou is not here. Now, there's no one else better to hide a body with than the very same police department that would be investigating where it went. And we know that no one else saw Lou on August 18th. We know that no one had any account of him on August 19th. But there was something else on Karen's mind that night. And that's why Cam told you that in the middle of the night, he heard an alarm going off, and he ran to the Big Cat Sanctuary and he found a broken lock. That's plaintiff's exhibit number 1, members of the jury. He found a broken gate. That's plaintiff's exhibit number 2. And who did he find with the person who had cut that gate? The defendant. And what did he tell you was in her hands? A lockbox containing his father's will. That is the final piece of this puzzle, members of the jury. What brings all of it together. The motive that Ms. Beja had to take Lou out. You heard that he had asked her for a divorce, and you heard him tell his only son that if anything should happen to me, tell him to look at Karen. Now, you also heard about 2 different wills in today's case. One will that would have divided Lou's assets between his life's work, the Big Cat Sanctuary, his son, and Karen, as well as Cam's mother. But you also heard about the will that Karen ended up producing. And that, members of the jury, is going to be the most important piece of evidence that you take back into that jury room with you today. It is the best documented example of how far Karen Beja was willing to go to get Lou's money. This is plaintiff's exhibit number 3. And if you look at this will that Karen ultimately produced, you'll see exactly why it was so important that she take it. And so first you heard from Taylor Pride today why these signatures didn't match up. Why the signature on Lou's court filing documents that he had signed just 2 days earlier didn't look anything like the signature that he was supposed to have signed on June 14th. He also told you that there was something else suspicious about this will. And that was the person who was supposed to have witnessed it, Samantha Lane. He told you that Samantha Lane said that she did not see Lou sign this will, that she was threatened by Karen, and that's why she signed it, despite it being a lie. Signatures that don't match up, and a first-hand witness that told you that Karen used this will just to take all of Lou's money for herself. And what is the result? A son that has not only lost his father, lost any sense of peace or closure, but he lost his job. You heard that just a few days later, Karen would fire him from Wild Big Cat Sanctuary. You heard that he lost his inheritance because she had swapped out the will that was supposed to give him his birthright. That is why Cam Donaldson brought this case today. And because he brought the case, we had 4 things that we needed to prove you. We needed to prove to you that Lou Donaldson was in fact dead, that Karen either recklessly or intentionally was the cause of that death, that the death of Lou Donaldson caused damages to Cam, his son, and that Karen is the cause of those damages. Now, members of the jury, we have proven all 4 of those elements to you today by a preponderance of the evidence. And remember what that means, that each of those things is more likely than not to have happened. Now, as to the first element, to Lou Donaldson's death, that's a practically undisputed matter in this case. You didn't just hear Cam tell you that he hasn't spoken to his father in the last 8 years. You didn't just hear our own expert, Taylor Pride, tell you that he believes Lou Donaldson to be dead. But you heard defendant's own expert, say that Lou Donaldson was declared dead. The only person here today that is trying to tell you members of the jury that Lou Donaldson is still alive is the defendant. The person that had all she had to gain from his death is now the one saying that he's still here. And that's what brings us to our second point. Karen Beja caused Lou Donaldson's death. Her alibi doesn't stack up. She forged documents in order to take all of his money. And the reason why, members of the jury, is because Lou had asked her for a divorce. That she saw her golden ticket getting ready to walk out the door. And she told you that she couldn't trust Cam. And that's why she had to do something. That's more likely than not that whatever she did to Lou, she did it. Now, we heard from Cam about what losing his father has done to his life. The pain and the suffering that he's experienced because of Karen is clear. He'll never have that relationship with his father. He won't get to spend long days on the sanctuary working with him anymore. And he also told us how he lost his job. That's because of Karen. Now, there's not a dollar amount in the world that will ever bring Lou Donaldson back. But we are asking you today to find for Cam, for his inheritance that he was robbed of, for his loss of income from losing his job, and his pain and suffering, in the total of $2.25 million. Now, you're about to hear opposing counsel get up here and say Cam doesn't deserve a penny. But they don't get to decide that, members of the jury. You do. You can give justice to Cam. You can give him closure. Find the defendant liable and don't let her win. Thank you.
Thank you, Mr. Pyron. For your information, you'll have 1 minute and 40 seconds for rebuttal. Does the defense wish to present a closing argument at this time?
Yes, Your Honor.
Okay, please proceed. And actually, I'm sorry, do you want a warning of any kind?
I don't think that I'm going to come close to the full time, so I should be fine.
All right, all right. Well, I will let you know if we wind up with 1 minute remaining in the off chance that we get that close, just so that you have a warning, okay?
Thank you, Your Honor.
Of course, thank you. Please proceed.
I hate her. I hope she is attacked and eaten by one of her tigers. That's what the plaintiff had to say about Karen Beja. And that's why we're here today, because the plaintiff hates Karen Beja. Granted, he has his reasons for hating Karen Beja. His father left his mother and married Karen Beja. His father left his life insurance policy to Karen Beja. And probably worst of all, his father left his business to his wife, Karen Beja. A business that the plaintiff spent 20 long years working at. A business that the plaintiff claimed should be his. Blinded by his hatred, the plaintiff sued Ms. Beja. But members of the jury, the legal system isn't in place to pacify children who hate their stepmothers. The legal system is in place to right legal wrongs. And before the plaintiff could be awarded any money in today's case, he had to prove that Karen Beja violated the law. He had to prove that Karen Beja violated this law. But while the plaintiff had to prove that Lou Donaldson is dead, he hasn't shown you a body. While the plaintiff had to prove that Karen Beja caused his death, he hasn't shown you any physical evidence that Karen Beja ever even harmed him. Now, I'm sure you remember plaintiff's counsel saying that all they had to do was prove that these elements are more likely true than not. That sounds simple. Each element just has to be over 50% probable. Opposing counsel described it as just a drop of water over halfway. But the thing is, once you put that drop of water, there can't be any other explanation that's more likely. In fact, there can't even be any other explanation that's as likely. Meaning that one offered explanation, it has to be the most likely one. In this case, that means the plaintiff had to prove that the most likely explanation for Lou Donaldson's disappearance is that Karen Beja caused his death. What seems more likely? Karen Beja killing her husband, an explanation that Summit Life Insurance found no support for, an explanation that the police found no support for, or Lou Donaldson crashing his plane somewhere between Statesville and Costa Rica. You heard today that there are 2,200 miles between Statesville and Costa Rica. You heard that that was a trip Lou Donaldson made often. You heard it was a trip Lou Donaldson made alone. Lou Donaldson could have crashed his plane anywhere on that 2,200 mile route, and no one would ever know when or where. What seems more likely? Karen Beja killing her husband, a man she loved, a man she was married to for years, or Lou Donaldson quietly disappearing to Costa Rica to be with his mistress. You heard today that Mr. Donaldson was a bit of a loner, that he would go and do things and he didn't always tell people when he was going or where he was going. What seems more likely? Karen Beja killing her husband or someone else killing him? Someone else with more anger, someone else with more greed, someone else with more hatred, someone who worked for Lou Donaldson, someone who knew everything about the wildlife business and wanted it to be theirs. The reality is, there are a million explanations that are more likely than the one the plaintiff wants you to believe, which is why the plaintiff hasn't met his burden on even the first two elements. But not only did the plaintiff have to prove that Lou Donaldson is dead and that Karen Beja caused his death, the plaintiff had to prove that he suffered damages as a result. But you saw Lou Donaldson's will. It leaves everything to Karen Beja, which means that the plaintiff wasn't meant to inherit anything from his father anyway. Now, the plaintiff claims that this will is a forgery. But you heard from Chris Renard, an expert in signature identification, and he told you that because of the similarities between Lou Donaldson's known signatures and the signature on the will, it was impossible for him to conclude that the signature was a forgery. Taylor Pride, the person the plaintiff paid to investigate the validity of his father's will, claims that the will is forged. He claims this despite the similarities between Lou Donaldson's known signatures and the signature on the will. He also claims that Karen Beja is responsible for that forgery. But despite having the expertise required to compare signatures and having Karen Beja's signature on that very will, he chose not to conduct that comparison. He chose not to confirm his suspicions. Taylor Pride also sat in front of you today and stood by his opinion that Lou Donaldson didn't withdraw a single cent after August 12th, 2012. But members of the jury, you saw the bank statement. You saw that there were 3 transactions after that date. In reality, Taylor Pride was wrong, and he refused to admit it. The only reason Taylor Pride was able to come to this definitive conclusion in this case is because the plaintiff paid him to do so. Now, because Lou Donaldson's will left his estate to Karen Beja, he can't claim to have suffered any damages as a result of Karen Beja's conduct. Lou Donaldson's disappearance was tragic, but members of the jury, the plaintiff's burden in today's case was not to make you feel sympathy for him. It was to prove that Karen Beja caused his suffering. And while the plaintiff had to prove that the most likely explanation for Lou Donaldson's disappearance is that Karen Beja caused his death, there are so many more likely explanations. It's more likely that Lou Donaldson went to Costa Rica. It's more likely that Lou Donaldson crashed his plane trying to get to Costa Rica. In fact, based on the evidence the plaintiff has shown you today, it's more likely that the plaintiff himself killed Lou Donaldson than that Karen Beja did. The plaintiff was with his father the night he disappeared. The plaintiff spent 20 long years working in his father's company without ever rising above an assistant's position. The plaintiff, despite being so concerned about his father, didn't hire someone to investigate his disappearance until it was time for Karen Beja to probate the will and collect the life insurance proceeds. The plaintiff says that all Miss Beja cares about is money, money, money. Well, even if that were true, Karen Beja wouldn't be the only one. You've seen all of the evidence, and it's clear that this story the plaintiff has concocted is just that, a story that was created from the plaintiff's perspective, a perspective which we've seen is clouded by the plaintiff's hatred for Karen Beja. But while the plaintiff can't see clearly, you, the members of the jury, provide a fresh perspective. You have the ability to look at all of the evidence clearly and objectively and come to an unbiased decision in today's case. We all have the right to leave what is ours to whoever we want. Lou Donaldson exercised that right. He exercised that right when he left his estate to his wife. He wanted her to take care of the cats that they both loved if anything happened to him. And he wanted her to have the life insurance proceeds so that she could do that. That may not be the result that Cam Donaldson wanted, but it is the result that Lou Donaldson intended. When you go back to deliberate, you will have 2 verdict forms to choose from. But based on the evidence you've heard today, verdict form B is the only logical option. Verdict form B is the only logical option because verdict form A required the plaintiff to prove every single element of his case to you, and he has failed to do that. Just because Cam Donaldson is blinded by his hatred for Karen Beja does not mean that he gets to take what Lou Donaldson left to his wife. Find Karen Beja not liable by signing verdict form B. Thank you.
Thank you, Ms. Fuller. Mr. Pyron, you have 1 minute and 40 seconds to give a rebuttal. closing argument if you would like to do so.
Yes, Your Honor.
Please proceed.
Members of the jury, opposing counsel just got up here and not only told you one of a bunch of different stories that they've told you over the course of this trial, but the most insulting story of all, that my client had anything to do with his father's disappearance or death. He didn't. Mr. Lou Donaldson didn't fly off to Costa Rica. There's only one explanation for where he went. And it doesn't come from anything that Cam said about Karen. Because nothing about how Cam feels about Karen will bring his father back. It comes from the mouth of Lou Donaldson himself when he told Cam, if anything should happen to me, look into Karen. That's more likely than not, members of the jury. That's how we know that she's the reason he's gone. Find the defendant liable. Thank you.
Thank you, Mr. Pyron. Thank you, everyone, for participating in today's trial. Everyone can turn your cameras on. You don't have to stand, Ms. Fuller, if you don't want to. I just want to say thank you to everyone for your patience in this new and interesting forum. I want to applaud you all for your use of technology and for making this a pretty seamless process for me and for the jurors. And lastly, I don't want to say most importantly, but it's pretty darn close. Thank you to the jurors for spending your evening here and for participating in this very interesting process. Just to give you, we're not going to do any like feedback or critiques this evening, which I think you guys have been told ahead of time. But I do want to let you know just a smidgen about me. I'm a deputy district attorney handling solely felony cases in Douglas County and Arapahoe County here in Colorado. I've been practicing for 2 years now. I graduated from law school in 2018 from the University of Denver, where I was on our national trial team. So I applaud y'all for sticking with it, even when things are so crazy. Good work, everyone. Get some sleep, and good luck with the rest of the tournament. Thank you.
Thank you.
Thank you.
Thank you.